Morning, Judge. I cannot hear you, sir.
How about now?
Yes, but you're very low.
Now, now you can hear?
I can hear you now, but your volume is low.
Yeah, let me, it's probably my settings. I have to go fix this.
It's coming up now.
Is it better now or is it just,
It's still a little low.
yeah, let me, how about now? Is that better?
It's a bit
No,
better.
I think it's a still same. This, anything?
Yeah, it's better.
Hey, is it still
Now
low?
you're low again.
That's weird.
Good morning.
You see how it was, is it full volume now or is it still low?
It's full volume.
Okay, I don't know. These machines, they're all
I hear you.
pain in the butt.
Are we going to be able to get through all the witnesses today, you think?
I do. Yeah.
Okay, good.
Yeah, apologies. We overscheduled in terms of time, but when they file these stipulation documents and they fundamentally change the application, right? It's really hard to know what's coming because yeah, at that time we only know that we've come to an agreement and we have no idea what that agreement looks like, and they always want to change the procedural schedule, so that puts us all in like the spot like we just can't predict.
I understand. I do not envy your positions, the both of you.
No, I just
It's
appreciate the fact that you guys, your services, you cut out time for us, and we're attentive to that fact. So, um, you know, obviously this is going much faster than we expected, but at the time we set this all up, we couldn't know that that would happen. It's just
there is plenty for me to do, so my feelings aren't hurt.
good, cool.
It's just times like these, I'm grateful that nicotine is in the food pyramid.
All right, I'm gonna go and drink some tea and stuff for our thing.
All right, I'll see you in a
See you in a
few.
bit. If you want to let him in, we could, and then just get going right at 9.
That sounds good to me. I don't think I'm actually a co-host this morning, so
Oh,
that's
I got to do
that.
that. It
Well,
doesn't default back. So one of these questions I had for Anna was, it's just useful information. If you have a multi-day hearing, right, you create one Zoom invite, right? It goes multiple days. And then the question I
yeah,
had for Anna was, with the YouTube link, and for folks viewing at YouTube, is the YouTube link different each day? Which is effectively a question about how Zoom and YouTube interact. And the answer is yes. Every day you're generating a new hyperlink to a YouTube page that's displaying what we're seeing here. So
yeah,
I thought that
that
was
makes
kind of
sense.
interesting to know.
Yeah, that makes sense. That's what I've seen on the YouTube channel.
Right. So you
Yeah,
have to update it each day, which is yeah. Anyway,
yeah, I'm fine letting everybody in. I'll do that now.
did they all? Oh, I see. You're letting them. Okay, they're all coming in. They disappeared off of
Yeah, no,
the waiting
they
room list.
should all be coming in now. If anybody wants to do a mic check, feel free to do that now.
Mr. Hearing Examiner, this is Peter Gould. Can you hear me?
Good morning, Mr. Gould. Yes, we can hear you loud and clear.
Thank you so much.
Mr. Hearing Examiner, can you hear me?
I can, Mr. Zedalis. Good to see you.
Thank you.
Doing the mic check. Keith Herman.
Good morning, Mr. Herman.
All good?
Yep,
Yep.
everything good.
Thank you.
Good morning, Mr. Hearing Examiner. Can you hear me?
Good morning. Yes, is that
Mr.
Mr.
Bain?
Bain.
Bame?
Thank
Mr.
you.
Bame. Yes, we can hear you. Ms. Clark, I think you're on mute.
I was, thank you.
Sure. Good morning to you.
Before we start, I'll commend everybody for you all have very professional backgrounds. We've all gotten quite good at this. I think for everyone I saw, and I won't identify the person, but it was like a virtual cave entrance. That was interesting.
Ready when you are, Judge.
It was trying to reference the Plato myth.
Yes, right.
Facing the shadows. Facing the shadows.
Okay, well, I show that the time is now 9 a.m. So if you're ready, Mr. Lee, we'll go ahead and go back on the record.
Yes, sir.
Okay, good morning. It's 9 a.m. on February 18th. This hearing in the matter of the PNM rate case 24-00089-UT will come back to order. Let's see, where we left off yesterday, we had gone through an order of the remaining witnesses that we were going to call. I did send an email out shortly before the hearing this morning to the parties, summarizing that list. Ms. Park, I believe you have your audio on. If you could please mute.
And ask him to forward.
Ms.
Yeah,
Park?
there we go. Yes, I can mute her. Oh,
Okay.
Good morning, Julie Park on behalf of the city of Albuquerque. Can you hear me okay?
we can, but
can.
your audio is in the background, Ms. Park. We're just trying to,
Yes.
there was some discussion. But anyway, I thought I could mute.
Okay, so turn off your mic.
Well, if everybody could mute, including, yes, when you're not speaking, that would be helpful. We didn't have an issue with that yesterday. After we had gone off the record yesterday, we did get an email from Ms. Zur reminding us that in setting that remaining order of witness examination, we had, I think, overlooked Mr. Barnes. So he, his, return to the lineup was reflected in the email that was sent out this morning. I think the plan is to take Dr. Zadalis from staff first this morning. Then both of the Department of Justice's witnesses, that's Andrea Crane and Doug Gigax, followed by Mr. Barnes. And then I think from there, we pretty much mirror the list that was originally submitted by the parties. Any questions about that order? Any preliminary matters from the parties that we should address this morning before we get started? Okay, seeing none. With that, let's see, Mr. Rossi.
Good morning, Mr. Hearing Examiner. Staff will call Dr. Bryce Zadalis.
Thank you. And Mr. Lee, if you would please swear in the witness.
Dr. Zadalis, would you please raise your right hand? You solemnly swear the testimony you're about to give in the matter not pending should be the truth, the whole truth, and nothing but the truth.
I do.
Thank you, sir.
Thank you. Go ahead, Mr. Rossi.
Thank you. Good morning, or should I say good afternoon, sir. Can you please state your name for the record?
Yes, my name is Bryce Zadalis.
And how are you employed?
I am an external consultant for the Utility Division of the New Mexico Public Regulation Commission.
And were you previously employed with the Utilities Division?
I was, yes, from January 2022 until December 2022.
Okay. As part of your duties, did you review this application?
I did.
And did you prepare testimony for this proceeding?
Yes, I did.
Do you have a copy of Staff Exhibit Number 3, the testimony of Bryce Zadalis in support of the unopposed comprehensive stipulation?
I do.
And was this testimony prepared by you?
It was.
And is this your exhibit, your sworn testimony in this matter?
It is, yes.
If I asked you the same questions today, would your answers be the same?
They would, yes.
And are the answers true and accurate to the best of your knowledge?
They are.
At this time, I will move to admit Staff Exhibit Number 3.
Thank you, Mr. Rossi. Pursuant to the stipulation, there's no objection. So Staff Exhibit Number 3 will be admitted into the record.
I have no further questions for this witness. He is able to be further questioned. Thank you.
Okay, thank you very much. And we'll turn first to the commissioners who are present. That's all of them. So good morning to all the members of the commission. Let's see, Commissioner Aguilera, do you have any questions for Dr. Zadalis?
No, thank you.
Thank you.
Good morning.
Good morning. Let's see, Commissioner Nybert. Okay. And last but not least, Chair O'Connell, do you have any questions for Dr. Zadalis?
No questions. Thank you.
Thank you. Hearing Examiner Ryan.
Just one question, Dr. Zadalis. I understand your testimony, and I'm asking just to confirm and then get you an opportunity to give additional clarification. Your testimony to indicate that it is beneficial that PNM has agreed to pass the costs of the ESAs through rates rather than the fuel clause. And I would hope, I just was wondering, is that correct? And if that is correct, understanding your testimony, just perhaps you can state again why you think that that's a good outcome for the multiple interests involved.
That is our position. That's my position as well. The benefits associated with this are that we're maintaining the status quo with respect to ESA recovery, which is that they flow through base rates and they're subject to banding for the different rate schedules, rate classes, as opposed to going through the FPP CAC as PNM's proposal had wanted, which would leave those costs unbanded. And there were some additional add-ons associated with PNM's initial proposal that through the stipulation have been removed, including a balancing account, recovering any over-under collect or either recovering or dispersing over-under collections associated with ESA recovery through the FPP CAC with carrying charges. Those have all been dispatched with. We're now moving simply to maintain the status quo and recover both the fixed price as well as volumetric contracts through base rates. So really maintaining the status quo is the fundamental benefit with this negotiation, having gone from PNM's initial position to what we've agreed upon in the stipulation.
If I understand correctly, part of the benefit one of the things that PNM seemed to want from fuel clause was immediate collection and then automatic adjustments. Is that correct?
That is correct.
I read an article not too long ago, and I intended to get together with the commissioner's advisors. It's just a general article about trackers in general within the utility context and the fact that they have the function of removing cost containment benefits, right? So if the utility has to predict out like how much an expense will be, then there is pressure on them to be accurate and then also to act within the budgeted amount. And when you have lots of trackers or riders, whatever you want to refer to them as, you sort of move away from that. And is that a unique concern in New Mexico? I mean, because we do know that a lot of the legislature has authorized a variety of trackers in a variety of instances, TEP, grid mod, the fuel clause. Can you speak generally about that subject?
I think hypothetically, the answer to that is yes. Obviously, it would depend on the individual facts and circumstances of the hypothetical tracker. But with respect to ESA recovery, the arrangement that we have right now is, as I believe Kyle Sanders testified to yesterday, PNM has proposed what the costs are for these ESAs, and those have been put into base rate. So it's that $82.1 million. So that's an upfront. We know that's what the cost is. It's not a situation wherein they can put through unvetted costs if the price of the batteries goes up, price of wire, whatever it could be, some material associated with the ESAs or else with the associated PPAs. So the cost containment in this particular case is that they have put into base rates a set amount. But if you were to have, just again hypothetically speaking, a rider wherein PNM or any utility for that matter simply tops up the balancing account with whatever costs they're incurring, and there's no either preset amount or else subsequent commission review of those.
I'm sorry, Dr. Zadalis, you broke up just for a second. Simply a balancing account with whatever costs they are incurring, and please continue.
Yeah, so if they were to have a balancing account and the utility was simply putting through whatever costs they were incurring at any one given time without either having a priori preset amount, such as we have with the case in the case of the ESAs and base rates now, then yeah, I could absolutely see issues with respect to cost containment, because what incentive would the utility have if they're not having these costs vetted to actually keep costs contained, if they can simply pass it through on a monthly basis, yearly basis, whatever that is, onto customers.
Yeah, and I guess I suppose you're just thinking about it. The argument for the trackers is probably something along the lines of it facilitates the process of perhaps rapid build out, and then the utility can achieve something quickly with some certainty that the costs will be captured. I mean, and for instance, in building out the AMI or the modern grid distribution system, I mean, it seems like if there's a desire to see that occur rapidly, then a tracker is a good thing. I'm not just speaking generally here. Is that a valid thought?
I do agree with that. You know, that would come down to, I guess, to the policy preferences of the commission. If there was some sort of program that the commission wanted to rapidly ensure that the utility deployed, then perhaps passing everything through you know, rider or tracker, whatever it might be, some sort of bill add-on, that might be warranted. But in this particular case, that's not the agreement that everybody arrived at. But I will also say, you know, there are, with respect to trackers, they do provide a benefit for the utility with respect to regulatory lag. It does eliminate that, or seeks to eliminate it in theory.
All right. That was all my questions, Mr. Zadalis. Thank you very much.
Thank you.
Good morning, Dr. Zadalis.
Good morning.
I just have a couple of questions, and my questions relate to, you talk about a provision in the stipulation. This is on page 10 of your testimony, whereby the utility will establish a regulatory asset or a regulatory liability for the difference in the actual ESA costs compared to the forecast. Can you explain to me a little bit more how this provision will work and what it will mean, I guess, to ratepayers?
So my understanding of the regulatory asset or regulatory liability is that PNM has put into base rate saying that they're projecting to be able to recover $82.1 million worth of ESA costs in their future test year. And so this regulatory asset, in my understanding of it, if PNM was to undercollect on the $82.1 million, then there would be a corresponding, the delta between those two numbers would be in this regulatory asset. Or if they were to overcollect, I'm sure PNM, maybe they would love to overcollect and have a blowout sales year in their future test year. In that case, they likely would have a regulatory liability wherein they actually owed customers money because they've overcollected for the ESAs through base rates.
And just sorry to clarify on that, Mr. Dallas, am I correct to understand that the uncertainty relates to the actual operational date of the assets? Is that correct?
I think I did listen to the testimony from yesterday. I think that's part of it.
Hang on,
Mr.
Lee,
everybody.
It's freezing again. So I think I did listen. Go ahead, please.
And Mr. Lee, perhaps, sorry, if we maybe just turn off your video as we did yesterday, if that'll help with that.
Thank you.
Yep.
Go ahead, sir.
Thank you, Mr. Lee. So I think to your question here, Examiner Ryan, part of it is having to do with the delay, basically, or the lag between when the volumetric ESAs are coming into service versus what the dates of the future test year in this case are. However, I would note to the Commission that the volumetric contracts or the volumetric ESAs, those account for, I think it's roughly about $19 million of this total $82.1 million. So there is, it's not, I would have to speculate here that's not only about ensuring that there's, you know, adequate recovery over this potential lag period in which the ESAs are being charged in base rates or else, you know, coming into service. But this also serves to ensure that the fixed price ESAs are also being recovered. And that might get to some issues to at least mollifying some issues associated with the imputed debt issue that PNM had previously mentioned and brought up in their testimony.
So that's an interesting point. And I guess the follow-up question I'd have for you is, you know, regardless of, so if your point is that what we heard yesterday from the utility may not fully disclose the concerns that are generating their, you know, concern about having the regulatory liability in place, regulatory asset in place, it sounds like to the extent to which we have the liability also functioning, there should be no downstream penalty to ratepayers. And in other words, the negotiation has addressed this regardless of why it's happening. Is that accurate or no?
I think it's relatively accurate. Yeah. So in the negotiation, we're obviously trying to balance the interests of the ratepayers and all the different parties to this particular proceeding, as well as to the utility. So to offer an asymmetrical tracker, or in this case, an asymmetrical, you know, regulatory asset or regulatory liability, was just not going to be palatable.
Right.
So we've included a symmetrical mechanism to ensure that the interest of all of the parties to this stipulation can be fulfilled and upheld.
Thank you. Sorry to interrupt, Hearing Examiner Crank. Yep.
No, that's really my question. I think I have the answer that I was looking for.
But if I may make one other point, is that okay if I make one other point?
Absolutely, please do.
Just a clarification. I didn't mention it before, but the fixed priced ESAs that constitute, I think again, it's roughly about $63 million worth of the ESAs that are in base rates. By the test year, they will all be in service.
Okay. Very good.
Okay. All right. Thank you very much, Dr. Zadalis. I appreciate it.
Thank you for your time.
Let's see, Mr. Rossi, you have any questions on redirect?
I do not, thank you. One thing though, I do have a request from our staff that yesterday we had the subtitles turned on the YouTube feed, and they're wondering if it would be possible to turn it back on today. It's probably the show captions, but I didn't want to accidentally set it without permission.
That's very interesting. I have no idea how one would do that. What I will do, Mr. Rossi, is I'll ask our paralegal to see if she can figure that out. I can't guarantee anything though, but I will do that.
Okay. All right. So unless there's any remaining questions from any of the commissioners for Dr. Zadalis, then I think that Dr. Zadalis, you can be excused, and we very much appreciate you taking the time to be here today. Thank you.
Thank you again.
Okay. That brings us to the New Mexico Department of Justice. And it looks like Ms. Barrett has turned her camera on, so I'm assuming this is your witness.
Yes, good morning.
Good morning.
Good morning, Ms. Crane.
Good morning.
Oh, hang on. Let me get, good morning, Ms. Crane. Let's see. Mr. Lee, can you please swear in the witness?
Ms. Crane, would you solemnly swear the testimony you're about to give the matter now pending should be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you, ma'am.
Okay, go ahead, Ms. Barrett.
Right. Good morning, Ms. Crane. Could you state your full name for the record?
Yes, my name is Andrea, middle initial C, last name Crane, C-R-A-N-E.
And how are you currently employed?
I'm president of the Columbia Group, and for this engagement, I was hired by the New Mexico Department of Justice as a consultant.
Okay. Are you familiar with the unopposed stipulation that was filed in this matter?
I am.
And do you have in front of you what's previously been marked as NMDOJ Exhibit Number 1?
I do.
And do you recognize that document?
Yes, it's my testimony in support of the stipulation.
Great. Does it have any attachments or addendums?
It has one exhibit, which is the list of testimonies that I have previously filed in other cases.
Okay. Was the testimony and the attachment drafted by you or under your direct supervision?
Yes, I prepared it.
And is the testimony and attachments true and correct to the best of your knowledge and belief?
Yes, it is.
Do you have any substantive corrections to either today?
No.
If I were to ask you these same questions today under oath, would your answers be the same?
Yes, they would.
All right, hearing examiners, I'd like to offer NMDOJ Exhibit number 1 along with the attachment into the record.
Thank you, Ms. Barrett. Pursuant to the stipulation, there's no objection to the admission of this exhibit. So NMDOJ Exhibit 1 is admitted into the record.
Okay. I have no further questions for Ms. Crane and tender her for further questioning.
Thank you very much.
You're welcome.
Turning first to the commissioners. Commissioner Aguilera, any questions for Ms. Crane? So you're shaking your head no.
No, thank you. Good morning, Ms. Crane.
Good morning.
Thank you. Let's see, Commissioner Nybert, any questions for Ms. Crane?
I do have one question, if I may.
Excellent, please go ahead.
Ms. Crane, in my limited understanding, because I'm pretty new to this, is that the Department of Justice represents all of the ratepayers, if you will. Is that a correct understanding?
The Department of Justice, for purposes of utility matters, in as far as I've been involved, represents primarily residential and small commercial customers. I think that may be a statutory limitation, although I'm not 100% sure of that.
It is a statute. There's a statute that directs the Department of Justice to represent ratepayers in the context of commission proceedings.
And that would be all ratepayers, or all the smaller ratepayers anyway.
Yes, primarily residential and small commercial.
Okay, thank you. What I'm wrestling with is the paragraph that requires PNM to make a one-time shareholder contribution of $1.5 million to the Good Neighbor Fund, and wrestling with if it's in essence a requirement now. It's not a gift, it's a requirement. And how does that factor into the issue of whether it's in the public interest or not?
Well, I think speaking just for the New Mexico Department of Justice and our participation in the settlement negotiations, this was not our primary issue. You know, we were focused primarily on the overall revenue requirement, as well as on the distribution of that revenue requirement among customer classes. There were several issues like this that were brought up by other parties, and certainly the Department of Justice would always welcome a contribution from a utility company that would benefit ratepayers, as this one will do. But it was not primarily at our initiative that provision was included. So while we're happy that it's there, we most likely would have supported the stipulation given the other elements, specifically those regarding the revenue requirement and rate design.
So again, help me work through this, because when something's required, it's no longer, in my words, a gift. And so it's just part of the formula, of assessing what we're all trying to do here, and that's find that fine line between affordability and the desire to encourage investment by the utility. And so I'm just looking at that one piece, and albeit a little piece, and really grappling with how that meets the public interest due to the fact that in essence, some of your ratepayers that you represent will be paying into that. There'll be some of your ratepayers that may be the recipients of the benefit of that particular contribution, but I'm wrestling with the benefit side to 40 of the payers.
Well,
I just was looking for some help as to how to get my arms around that.
Yeah,
Okay,
I'm
well,
sorry, hold on just one second before you answer, Ms. Crane. Mr. Lee, Commissioner Nybert broke up during that. Did he break up on your end as well?
He was breaking up a little bit on my end as well.
Right.
He's
Mr.
picking
Lee,
up
are you
on
there?
mine, and yes, and you were frozen for a second. Go ahead, please.
All right, sorry, wait, no, let's stop. Mr. Lee, before everyone starts talking again, we need to make sure the record accurately reflects what was said. So, where did you stop? Where was it broken up for you, Mr. Lee?
I got your statement before you answered Ms. Crane, Mr. Lee, Commissioner Nybert, and that's all I got.
I don't quite understand that, Mr. Lee. Can you run that by me one more time? Where did you cut off?
Commissioner Ryan's statement about stopping Ms. Crane from answering and was making a comment. I think that Commissioner Nybert was breaking up.
Yes, when I heard him breaking up as I was going, and I understood Ms. Crane to be nodding her head, and I heard hearing examiner Cryan-Kemp also indicate that Commissioner Nybert broke up as he was speaking. So I just wanted to make sure that the record accurately reflects the question that Commissioner Nybert asked Ms. Crane. So if you captured all that, Mr. Lee, then that's fine.
Let me just ask this. Ms. Crane, do you understand the question that Commissioner Nybert is asking you?
yes, I believe I do.
Okay, because I'm looking at the real-time transcript and I do think it's here. So why don't you go ahead and answer that question?
Okay. First of all, I don't agree necessarily that the $1.5 million contribution to a Good Neighbor Fund or any contribution is considered now a permanent requirement. At least speaking personally, I don't view it that way at all. It certainly is a requirement in this particular stipulation for this particular case, and it may have been in past stipulations, it may be in future stipulations, but in terms of it being some sort of legal requirement, while I'm not an attorney, as a witness, it's my understanding that this is not a requirement going forward in future cases. It's really limited to this case. In terms of it being a public benefit, just to clarify, this will not go through any ratepayer rates. This is a contribution by the company. So there won't be any class of ratepayers that is actually funding this $1.5 million. There will only be ratepayers that will be benefiting from this $1.5 million. So I think in that regard, it's clearly a public, it's clearly in the public interest because none of the ratepayers will be paying for it, and at least some of the ratepayers will be benefiting from it. So I hope that answers your question. If not, I'll take another shot.
So when they calculated the rate of return for PNM in this case, and I keep hearing the number 9.47 or something along those lines, that number is calculated before this number?
Yeah, that number is calculated based on the rate base and the operating expenses that are anticipated during the future test year. The $1.5 million that's discussed here is not included at all in that calculation. So that rate of return is completely independent. PNM would fund this $1.5 million from something other than rates, or at least it does not go through the rate making process at all. So you can view it as coming from its shareholders as opposed to its ratepayers.
In your introduction, or it was indicated that you're
Breaking up again.
Hang on,
Yes.
Commissioner Nybert. Yeah, you broke up again there.
consultant, and I
Commissioner
assume
Nybert,
that you
hang
are a
on.
consultant.
Yeah, Commissioner
I
Nybert.
I suffer from
You broke up
from
there.
the same.
Breaking completely up. I don't
Yeah,
hear
no,
him.
I couldn't hear my
Yeah.
Commissioner Nybert. Yeah,
Commissioner
everyone
Nybert,
was.
can you try repeating your question?
Yes, sir. I suffer from the same bandwidth issues that Mr. Lee suffers from. I'm unfortunate. That's why I'm turned off the video. But my question is, Ms. Crane, is that you were introduced as being an independent consultant, and I assume that means you consult not only in New Mexico, but for many other, maybe in other states. Would that be an accurate assumption on my part?
Yes, sir. I've been consulting since about 1987, and I've testified in well over 400 cases in roughly 20 plus states in the District of Columbia.
And in your years of consulting and your vast array of consulting, would this be a bit of an unusual provision to see in a case?
I don't think so. I mean, this specific provision may not appear in other stipulations, but in my experience, it is not unusual for various parties to raise very specific requests as part of a settlement negotiation. And so I don't think that it is at all unusual to have this type of requirement in a stipulation, although this specific requirement, relating to a contribution specifically to a good neighbor fund, is I probably haven't seen in many cases. I'm not even sure I've seen this specific one in any, but certainly it's not unusual to have a specific requirement like this, whereby the company or the utility agrees to some sort of financial contribution from shareholders.
Okay. Thank you. That's all the questions that I had.
Thank you.
Thank you, Commissioner. Next up is Chair O'Connell. Do you have any questions for Ms. Crane?
I just thank Ms. Crane for her testimony and work on this case, and I have no questions.
Thanks,
Thank
you. Hearing Examiner Ryan, any questions for Mr. Crane or Ms. Crane?
Yes. Ms. Crane, how are you?
I'm fine. How are you?
Very good. I'm sorry that this is your last case, Ms. Crane. That's very sad to hear.
Well, maybe I'll change my mind. Who knows?
Yeah, we'll have to try to persuade you. Yesterday, I asked Mr. Monroy, we have lots of testimony in this case from varying interveners, which indicates the stipulation is desirable because it is a significant retreat from the ask in the stipulation. And the question I tried to ask as delicately as possible was, I can understand as a pure matter of negotiation, when you start out at a high place and come lower, there is a sense on the other side of the transactional table that some benefit has been achieved, but that benefit could be illusory. So I'm wondering, do you have any views about that subject matter when you saw this particular application?
Yes. First of all, when I first reviewed this application, what occurred to me was that it was going to be difficult to get a really low number. You may recall have frequently testified that virtually the entire rate increase being requested by a utility, should be denied. And in some cases, even that there should be rate refunds. In this case, given the amount of plant that was anticipated to be added during the future test year, given the ESA issue, my first impression was this was going to be a higher number than I would have liked, but there wasn't a whole lot that I was going to be able to do about it. So that's kind of, I guess, where my analysis started. And then as we ran through specific adjustments in preparation for filing pre-file testimony, we began to get a good sense of what we thought our litigation position would be. And from there, extrapolated to what we thought a fair and reasonable settlement position may be.
And the lion's share of the increase that we're now dealing with, the 105 million, looks like it comes from the investments in the distribution, transmission, generation assets. And I mean, it's at the Attorney General's position that those are essential to provide reliable service for PNM's ratepayers, because it doesn't seem like you're coming off, like there's no major deduction to that sort of suite of investments.
Well, I have a couple thoughts in that regard. First of all, I'm not an engineer, so I've reviewed the testimony, but I can't really comment on every project that's being proposed in the application. Certainly, there is nothing that stands out to us as being gold-plated or something that would be unnecessary. Now, there's always a question about timing. There's always a question about timing as to when a utility actually makes an investment, and two is with the future test year, as you know, there's always a question mark about when the investment will actually go into service and whether the company will actually meet its projections. And that's problematic. And there's really, we're really limited as to what we can do, given the fact that the company has the right to file a future test year. In terms of making adjustments to the company's claim with regard to specific investments, we certainly assumed in developing both our litigation position and in developing what I would consider to be a reasonable settlement position, we assumed that the company would not, in fact, meet all of its projected plan additions. And I believe Mr. Sanders testified yesterday with regard to the $12.9 million that while the company considers that or booked it in their illustrative cost of service as an operating expense, they recognize that all parties may not agree that that's where the $12.9 million comes from. So I don't think that you can assume that the Attorney General would have necessarily booked all of that $12.9 million to expense. In fact, I think we most likely, certainly if we had litigated, we would have had a plant and service adjustment. Let me put it that way.
Okay. And just so I understand, is the 12.9 million part of the negotiation, which accounts for the potentiality for the adjustment that would have been litigated?
Yes. So
Okay.
the 12.9 million, I mean, the way the 12.9 million came about is we really agreed on an overall revenue or revenue increase, I should say, not a revenue requirement. Well, I guess we agreed on both. So the 105 million is what was agreed to. And then when you start to go through very specific adjustments like that we all agreed to, like cost of capital and capital structure and a few other things, frankly, the $12.9 million is a fallout number of what's left. It's a plug number, if you will, to get to the 105 million. However, in evaluating all of the underlying numbers and our potential adjustments, the 105 million is certainly, in my view, a reasonable number, and therefore the 12.9 million is reasonable as well.
Okay. I was asking Dr. Pitts yesterday, and I think as the Attorney General's witness in this case, I mean, I'll just ask you a rather straightforward question, which is, do you see the utility having a pathway to controlling affordability for the many low-income ratepayers that it has?
Well, I think given everything that's on the utility's plate, part of which are statutory requirements with regard to carbon-free generation and the other sorts of issues that are out there, I think it's going to be very difficult from a rate-making perspective in order to, certainly in order to lower rates. I don't see that happening at all. The problem with affordability does not seem to be getting better. It seems to be getting worse. And it may be that at some point in time, there may be a public policy issue that would require some sort of other state funding or federal funding. For example, one could argue that the move to carbon-free resources is really a social benefit that should be paid for, at least in part, through something other than utility rates. I'm just throwing that out there as one possibility or one path. If you're going to continue to essentially rebuild your system with carbon-free resources in this environment, I think that the only path for rates is an upward one, unfortunately. So I guess the other potential is to, make economic improvements generally that help reduce the number of low-income people in your state. And that's sort of trying to attack it from the other side of the problem. But I don't see rates going down anytime soon. Let's put it that way.
From the DOJ's perspective, there's lots of discussion about the movement towards unity in terms of each class providing its own full cost of service. Is that something you think is, from the DOJ's perspective, I guess, well, let's put it this way. What is the DOJ's perspective about that?
Well, you probably should also have this discussion with Dr. Gigak since
Yeah.
he's really their witness, but I'm happy to tell you what I think if you're interested. And
Yes.
I think, well, first of all, there was testimony yesterday that the whole issue of cost of service is really an art and not a science. And so first of all, various experts can disagree about what the actual cost of service is, number one. Number two is class cost of service is to some extent based on arbitrary classifications of customers. So in fact, you have two residential customers that are paying the same rates, and they may actually generate very different costs for the utility. So in essence, we can never really have true cost of service where every customer is paying their individual costs. I think as a general policy, as has been expressed by other witnesses, recognizing all of those problems, there is a benefit to trying to get each class close to its cost of service. Generally, I think that's a good policy. However, there are obviously other issues that need to be considered. There's been a lot of talk about gradualism, for example, and rate shock. Again, there may be public policy issues that for one reason or another, the commission or the state feels that a certain class should be handled in a certain way. Obviously, there are also non-discriminatory restrictions on, how much flexibility the commission has to approve rates that, are that could potentially be deemed to be discriminatory because there's a statutory prohibition against that, I understand. So it's a very complex issue. But as a general rule, yeah, I think most of us would agree that if we could agree on what a cost of service is, then we would agree that one of the objectives should be movement towards that cost of service.
And then my understanding, one policy argument is that to the extent to which there is a need for subsidization that occurs outside of the context of rate setting and is an express action within the legislative branch to achieve, because you're doing social policy rather than identifying sort of empirical cost of service questions. Is that a view?
It is, as I mentioned, you may decide that there needs to be other funding sources in order to promote some public policy and still have affordable rates.
At page 15 of your stipulation testimony, you noted that the NMPRC previously rejected a request by EPE to recover ESA costs in the fuel clause, EPE's fuel clause, instead required EPE. Do you recall the number of that case out of curiosity?
I do not.
Okay, I'll have to go find. That's fine. Do you think that PNM has through legislative enactments obtained too many opportunities for trackers or riders?
Yes, I'm I'm not a big fan of trackers or riders. I think they send the wrong signal. Generally speaking, I think they send the wrong signal to the utility. I think the utility loses quite a bit of its incentive to control costs when you have a proliferation of trackers. So I definitely am not a fan of trackers and would like to see fewer rather than more trackers.
What's the ostensible benefit that, to the extent to which we can presume the legislature was doing something rational and in the interests of the public, what would be that interest and how is it served by the tracker?
Well, I think, the trackers sort of in the current generation, I think, actually go back to the fuel clause crisis, of like the 70s, right? And then the fuel costs were so volatile. And that was, the fuel trackers were in many states the first sort of tracking mechanism, of the modern era, I think. And I think the view was that this is such a volatile cost that at some point, it's gonna come down. And therefore, we want to make sure that ratepayers are able to benefit from reductions in fuel costs. Now we have a proliferation of trackers, many of which are never going to come down. Something like grid mod, I certainly wouldn't expect that to come down because I would expect that there will be maybe another grid mod program once we start to reach the end of the current one and those sorts of things. So I think, though, that there was some, my own my own belief is that it really was done more for the utilities, more to protect the utilities than it was to protect the customers, although the argument could be made that with volatile costs, both parties benefit. But in my view, it protects shareholders more than ratepayers. It reduces the incentive for cost containment by the utility. And I think, and I don't think that you have had a commensurate reduction in returns on equity with the proliferation of trackers. So I think that if you wanted to make everything a reimbursement system, you could do that. You could say at the end of the year, the utility would file one set of financials, and there'd be some sort of general overall true up to some sort of baseline, return. But that's kind of not the way we operate, and again, that removes important incentives.
Because at that juncture, you'd be basically looking, I mean, the sort of premium you get above the no risk return. I mean, effectively, if you had a utility completely predicated on reimbursement, there should be nothing above the risk-free return, right?
Exactly.
Yeah. Page 23 of your testimony, you note here, and I just want to get clarification on what you're saying, and I just might be that I'm missing something, but that's fine. Lines 19 through 22 of page 23. In addition, in the PNM revision, the company stated that it discovered an error in its application relating to cost of removal. Correction of this error would have significantly increased its revenue requirement, and PM chose not to reflect this correction in stipulation exhibit 1. Can you just explain what that is? I was a little confused when I read that.
Sure. Basically, and then this actually was in one of the erratas filed by Mr. Sanders, and in essence, what the company did was cost of removal is a cost to the company, and so generally it increases rate base. And instead, it's my understanding, and PNM can confirm this or correct me if I'm mistaken, that I'm sorry, I heard someone.
Yeah, I think it was Ms. Schur was unmuted for a moment. And
Okay.
said,
She's
hey.
muted now. I think.
Okay.
Yeah, I muted her.
Okay, great. It's my understanding from Mr. Sanders' errata that instead of increasing rate base, which cost of removal ordinarily would have, that the company's model it showed it as a rate base reduction, and therefore their rate base, as stated, is lower than it would otherwise be, and that it should otherwise be, actually, just from an accounting perspective. The company chose not to include this correction in its stipulation exhibit number 1. I did reach out to Mr. Sanders for additional information about the magnitude of this correction, and felt that it was important to just consider that in the overall review of a possible stipulation settlement number.
Okay. When the commission receives, in this case, this is a case in which a stipulation came in prior to the filing of direct testimony. And, I think there's obvious strategic reasons why that would be desirable, depending on one's perspective on the subject. Do you think that in this case, that's at all a hindrance to the commission's assessment of this particular stipulation?
No, I don't. I think that I know the Department of Justice had done sufficient analysis to feel comfortable with the revenue requirement, and obviously with the cost of capital as well, because that is a component of the revenue requirement. And when I say comfortable, I mean, I think we had a pretty good idea of where we would have ended up in litigation and where we would have probably ended up before the commission in a fully litigated case. And so I think other parties, had also done similar analysis.
Dr. Blank testified in his testimony. We had a brief discussion with him about this yesterday. The amount of resources dedicated to negotiating the settlement, and as I understand him, what he did testify there yesterday to was that, while it wasn't entirely clear what he was precisely saying, at the very least, as much energy went into this settlement as likely would have been dedicated to a fully litigated case. I think that's a fair statement of what he said. Do does the DOJ, I mean, as the DOJ's witness, are you thinking the same thing, or what, any comments about that?
Yeah, I think I would disagree with Dr. Blank
Okay.
on that. You know, the writing of testimony is is very labor intensive. I mean, I had done my numbers. I had a pretty good sense on what my schedules would have looked like, but in terms of, you know, putting the text together, I think that would have taken quite a bit of effort. And really the biggest part is getting ready for an adversarial hearing, especially when there's a lot of different parties involved. And so generally, as I'll speak personally, I mean, generally we work with the Department of Justice to prepare questions for all of the company witnesses, sometimes the intervener witnesses as well. We assist on the briefs and the reply briefs generally. And we would have had to review rebuttal testimony that would have been filed by PNM in response to our testimony. So I think quite a few resources, at least speaking personally, a lot of resources were saved as a result of this stipulation. And I hope that is reflected in, you know, at some point in rate case expenses.
I know you've participated in many different proceedings in different states throughout the country. And is it fair to say that New Mexico is unique in that the concentration of low-income ratepayers that exists within not only PNM service territory, but then EPE and, well, maybe not SBS, but PNM and EPE? Do you have any sense of the answer to that question?
Yeah, I believe, and I could be mistaken, but I thought that there was a statement in PNM's testimony that something like 40% of its ratepayers, or maybe 40% of residential ratepayers, were low income, which really shocked me. Because, you know, when you have such a high low income base, it's, you know, it's very difficult to get blood from a stone, right? So I mean, as the number of people that can kind of afford to pay diminishes, it really creates a very significant problem, you know, not only for the utility, but for the state, for customers, for everyone. So I do think that that New Mexico may be unique in that regard.
And then when you're out preparing your testimony for the Department of Justice, I mean, I guess my question becomes, how do we ensure, and I'm not asking this in any way as like a challenging question, more just, I'll be very interested in your thoughts, is like, how does the Department of Justice identify what it is that is in the best interests of that group of individuals? And like, how do you ensure can be certain that in fact you are doing what you think those individuals would want to be done? Do you understand my question?
I think by individuals, are you talking about low income individuals?
Yeah.
Or okay.
Yeah.
Okay. Well, I personally don't get too involved specifically in low income issues, because as the revenue requirement witness, I'm trying to just deal with what are the costs, and what do I think the overall revenues of the company are going to be, and is there the need then for a revenue increase? I kind of stop at the revenue level. So I don't really need to, from my perspective, get too involved in specific classes of customers, who's paying what, or even really in the affordability issue. Now, I know there are a lot of other programs, projects, cases that the New Mexico Department of Justice is involved in, that does delve more closely into those issues of low income, the policy issues, social policy, economic development, and how you assist those low income customers in getting out of that low income environment. But from my perspective, I try and just look at the facts that are before me and the numbers, and I try and evaluate with every rate-based component and with every operating expense component, you know, do I think that the utility needs to incur this cost in order to operate a safe, in order to provide safe and adequate utility service? And if they do, then, you know, I'm going to include it in my revenue requirement, even though I'm concerned about the overall impact. And then Dr. Gigax will take my number and try and figure out, is there some way to mitigate through banding or some other mechanism, the impact on specific customer classes. But yeah, I mean, I'm concerned because even though we've gotten the revenue increase down for residentials, for example, under 20%, I mean, that's a huge number. So it is a concern I have, but it's not really part of my function, to address that issue with that specificity.
The Good Neighbor Fund contribution, I was sort of just working through the math in my head, and we heard yesterday it's $175 or $175 annual cap for assistance, and I forgot who it was who said that might just represent one monthly bill for any particular ratepayer, particularly if you're high energy consumption and in an efficient house. Sounds to me like it's $1.5 million. I mean, if you just do rough math, that's something like, I'm terrible at math, but like 10,000 individual bills would be assisted, and whether that gets spread among 10,000 individual customers. I guess I'm trying to just get a sense as to even what does that contribution really do for this really big group of low income ratepayers that we have here.
Yeah, well, I mean, from my perspective, as I indicated earlier, that wasn't one of the really important items in the stipulation, and to the Department of Justice. It wasn't a die on your sword issue for us. It was brought to our attention by other parties, and while we're always, as I said, happy to have a company contribution, it's really a drop in the bucket. And when you look at the bigger issue, not only of what's happening today, where uncollectibles are today, but when you look at what the cost that the company is likely to face in the future, that $1.5 million, while welcome, is certainly not going to solve the very serious issues that ratepayers are facing, in my view.
Thank you very much, Ms. Crane. It's always a pleasure to speak with you. I'm sorry you're retiring.
Oh, thank you. I'll continue to follow you on YouTube.
Okay.
Good morning, Ms. Crane. Thank you for being with us.
Good morning.
I just had a few questions I wanted to follow up on some of the subjects that have been brought up before in your testimony. One of the threads I want to pick up on, hearing examiner Ryan asked you a question that I was going to ask you about, how you and the DOJ sort of balance the interests of the ratepayer classes that you represent. And I appreciate your answer. It reminds me a little bit of the dialogue that we had with Dr. Blank yesterday about the interests of the city. And I heard you say that your role in I guess assisting DOJ, advising DOJ, is really focused on the revenue requirement. Can you talk a little bit to, in your capacity as working on the revenue requirement, and you talked a little bit about how you approach that. Does that depend on the interests of your client, or the interest of the classes that they are representing, and how that might differ depending on the interests that they would represent? Do you understand sort of what I'm getting at there?
I do, and I'd have to say that it does not really depend on it. From my perspective, on the revenue requirement, I don't really think about whether a cost is a residential cost, or whether it's a commercial cost or an industrial cost. I'm looking at sort of a more macro level. Does the utility has certain requirements to provide service to all customers, within its service territory, and is this cost needed in order to provide service? I'm looking more in terms of the way that I'm reviewing, especially on the expense side. One of the things I look for a lot is detailed information about specific expenses, particularly when they are non-labor types of, like, new projects, new programs that the company wants to implement. In this case, there were several new O&M type programs, and so I'm looking to does the overall utility need this, and have they provided sufficient information to justify this? Because lots of times it may be a perfectly good program, but the supporting documentation is so vague that, in my view, it just hasn't been supported. And I probably would have made a number of adjustments if we had litigated, based on the analysis that they just they haven't proven their number, so to speak. But at least from my perspective, I am not trying to differentiate among the classes. That's Dr. Gigax's job.
Okay, that's helpful. And sort of related to that, when we're talking about the revenue requirement, I'm looking at a statement you made on page 28 of your testimony. You're asked whether the stipulation is in the public interest, and the statement here that I'm interested in, you say that the PNM stipulation will result in a revenue increase that is significantly less than the 174.3 million proposed by PNM, and is in line with the increase that NMDOJ would have recommended in direct testimony. And this sort of got at something that I've been thinking about, and I think that Hearing Examiner Ryan and I have talked about at different points. I don't know if I just broke up there. I'm not hearing out of this side of my headphones, but as long as you can hear me, I'm fine. Yeah, I can hear you. Hearing
Okay.
Examiner Ryan, can you hear? Okay.
I did. There was a weird sound that happened, but it didn't interrupt what you were saying. So yeah.
Okay. Well, let me try to rephrase that question. So, I'm looking at that statement, and from reviewing the testimonies that have been submitted by a lot of the interveners in this case, there's a lot of emphasis placed on the sheer size of the decrease in the revenue requirement. When they're asked the question, is this in the public interest? The answer oftentimes is yes, and in part because there's been this 40% decrease. And I'm looking at that and I guess struggling to understand whether that in and of itself is an indication of whether something's in the public interest. To me, the more interesting question is the second part of your statement there, that it's in line with what you would have recommended. And I'm wondering if you can help me out and opine a little bit on the right way to look at that revenue decrease in the context of determining what's in the public interest.
Yes, I'd be happy to. I don't think by itself the 40% reduction would indicate that it's in the public interest. Similar, I guess, to the discussion I think you had yesterday with someone about the fact that it's a unanimous stipulation. Should that mean that it's in the public interest? And it's a good indication, but not necessarily. I'd be happy to talk a little bit about my process. When I went through and I looked at the numbers, I looked at the specific adjustments, adjustment by adjustment. As I indicated, the first thing that struck me was I was not going to be able to get a really low number here. And as I indicated in my testimony, I would have filed a litigation position that was less than $105 million, but it would have been, and I don't want to get into too many specifics, but it would have been probably slightly under 50% of what the company was asking for. It wasn't going to be 10% of what the company was asking for. It was going to be more in that 50% range. That would have been my litigation position. I then sort of took my litigation position and I went through adjustment by adjustment, and I decided what I thought the likelihood of me prevailing on each of those issues would be. And I included capital structure and rate of return in there because even though I'm not the witness who would have testified on those, they're very important components of the revenue requirement. When I went through and I did kind of an analysis of where I thought we may end up, I will tell you that it was very close to $105 million. I then went back after we began to look at specific components, and I reran my numbers with the capital structure and the ROE that we were all sort of coalescing around in the terms of the stipulation, and also one other adjustment, which was the revenue adjustment that the company also filed in its errata. They increased their revenues. I took my starting position and just made those 3 changes, and that increased my revenue requirement. And then I also looked at that number that we talked about earlier, the cost of removal number that was not in PNM's stipulation exhibit 1, but which I knew was hanging out there and was a real sort of cost to PNM. And if I had basically won every one of my adjustments, given the capital structure and ROE that were in the stipulation, and considering that cost of removal adjustment, if that had been considered, again, we would have ended up right around $105 million. So given all of that, I felt that $105 million was a reasonable place to kind of settle on.
Right. Okay. Let me ask you about a couple of other items in your testimony. One, you mentioned a couple of times, and I'm not sure if I'm not sure how closely you looked at this, but I see several references in your testimony, in particular one on page 18, to the expansion of fee-free in-person payment options at Western Union locations.
Yes.
I'm not sure how closely you looked at this. We had a brief discussion with Mr. Maldine yesterday from staff about this, and can you expand a little bit on why this is in the public interest? I'm not sure again if you heard exactly what that dialogue was yesterday.
Yeah, I did hear the dialogue, and I think that there was a little bit of confusion about what happened in the 270 case. So in the 270 case, PNM had proposed that there be the big issue there was they had proposed that the fee for credit card usage be socialized in rates. Right now, currently, credit card fees are paid. If you pay your utility bill with your credit card, you incur a fee, and that fee is paid by the person who used their credit card. There was a huge issue in the last case about whether that cost should be socialized or not, and the Department of Justice vigorously advocated against socializing those costs. And during the hearing, there was a lot of discussion about low-income people that don't have other options fee-free options to pay their bill, and and whether or not there should be an expansion of fee-free payments at Western Union locations. And I believe I testified that the Department of Justice would not oppose expanding fee-free payments to all Western Union locations. Our big concern there was the credit card fees, which were in the millions of dollars, not the hundreds of thousands of dollars. And so we do feel that extending the fee-free payment to all the Western Union locations is in the public interest. Yes, it's not something that will benefit a lot of ratepayers, but we do feel that it's important to provide an option for all people to be able to pay their bills without incurring an additional fee.
That might have been my fault for injecting the confusion. Thank you for going back and clarifying that. I couldn't exactly recall the details of everything we did there. Thank you.
Sure.
Yeah, and that's very helpful. That's I believe all the questions that I have for you, Ms. Crane. I really do appreciate your testimony. It's been enlightening.
Okay, thank you.
Let's see. Any further questions, Hearing Examiner Ryan?
No, thank you.
Okay. Ms. Barrett, any questions on redirect?
I don't have any redirect for Ms. Crane. I would like to take a very quick minute just to acknowledge again Ms. Crane's substantial positive contribution, not just to the DOJ's role in the regulatory field, but overall in her many years of service. And I think it's safe to say she's universally respected in this field and will be greatly missed in New Mexico.
Thank you. Thank you. It's been fun. It's been a great run. It's been fun. And that extends, I've had a wonderful relationship, not only with my clients, but also with utility people as well. And it's been wonderful. So thank you for that.
Well, thank you very much. I believe that that is all of the questions that we have for you, Ms. Crane. And with that, again, we very much thank you for your testimony today and all of your previous cases, and you can be excused.
Thank you. Thank you very much.
Thank you.
And if we could hear,
Mr.
sorry,
Hearing
go ahead.
Examiner, I would
Yeah.
like to echo those sentiments as well. I think anybody that has worked in this field for longer than a few years has always appreciated Ms. Crane's testimony and the clarity with which she presents her opinions. So thank you, Andrea. I really appreciate it, and we'll miss you.
Thank you.
I was going to say if we could take our break, that'd be very useful to me.
Yes. Yes. Let's take a 10-minute break. I'm having some technical issues, I think, on my end, and I need to work those out. So we'll come back at about 10:20. Hearing examiner Ryan, can you see me?
I can.
Okay, good. That's fixed then. Okay. So, Mr. Lee, are you ready, sir?
Yes, sir.
All right, then we will go back on the record. The time is now 10:21. And where we left off, we had just finished with the testimony of Ms. Andrea Crane, and we were about to start with Dr. Gigax. I believe that's Assistant Attorney General Gideon Elliott up to bat. Is that correct, sir?
Yes. Good morning, hearing examiners. NMDOJ calls Dr. Douglas Gigax.
Thank you. And Mr. Lee, if you'll please swear in the witness.
Dr. Gigax, would you please raise your right hand? You solemnly swear the testimony you're about to give in the matter of pending should be the truth, the whole truth, nothing but the truth.
I do.
Thank you, sir.
Good morning, Dr. Gigax. Would you please state your name and employment for the record?
Let me see. I'm getting some feedback here. Let me I do.
Okay. Dr. Gigax, can you hear me okay?
Yes, let me hey Gideon.
Yeah.
Yeah, let me I've got the YouTube on as well.
Oh, I see. Okay.
Let me turn that off.
Yeah.
A second. Sorry about that.
No problem.
Okay. Okay, there we go. Can you hear me?
Perfect.
Yes, we can.
Okay, sorry about that. I forgot to turn off the YouTube.
Could you just please state your name for the and employment for the record?
Yes, my name is Doug Gigax. I am currently retired from New Mexico State University. I am now employed as an independent consultant on behalf of the New Mexico Department of Justice.
And Dr. Gigax, for Mr. Elliott asked you on the question, just for clarification, since there was a glitch in the technology there, you do understand that you were sworn in. Mr. Lee did that, and you answered affirmatively that you're providing sworn testimony today, correct?
Yes, sir.
Thank you. Go ahead, Mr. Elliott.
And do you have a copy of what's been marked NMDOJ Exhibit 2?
Yes, I do.
And would you please identify that document for the record?
Sure. That is my testimony in support of the unopposed comprehensive stipulation.
And is this your sworn testimony?
Yes, it is.
And do you have any attachments or addendums?
To this document? No, I do not.
Okay. And was this testimony prepared by you or under your supervision?
Yes, it was.
And do you have any corrections?
No, I don't.
And if I asked you the same questions today, would your answers be the same?
Yes, they would.
Mr. Hearing Examiner, I'd like to move NMDOJ 2 into the record.
Thank you, Mr. Elliott. Per the stipulation, there's no objection. So NMDOJ Exhibit 2 will be admitted into the record.
Thank you. And I tender the witness.
Thank you very much. Okay, turning first to the commissioners. Let's see. Commissioner Aguilera, any questions for Dr. Gigax?
No questions for me, hearing examiner. Good morning, Dr. Gigax. Good to see you.
Good morning, Commissioner.
Thank you. Commissioner Nybert, any questions for Dr. Gigax?
No, sir.
Okay, thank you. And last but not least, again, Chair O'Connell, any questions for Dr. Gigax?
Good morning, Dr. Gigax. I have no questions, and thank you for your testimony in this proceeding.
Good morning, Chair.
Let's see, Hearing Examiner Ryan.
Dr. Gigax, I think Ms. Crane indicated that you would be the appropriate witness to ask the question about the movement towards unity in rates and the desire of the collective interveners, or so it seems, to move towards unity. And I asked Ms. Crane, well, is that something that DOJ is, and its witnesses are pushing for, and is that desirable? And I'd ask you if you could please respond and give your thoughts about that subject.
Yes, I think in general, the Department of Justice and me personally supports the idea of moving towards cost-based for all the different rate classes. I think we, in our history, is also to temper that, however, with concerns over rate shock and stability and those kind of concerns. But I think the current environment, we're seeing a movement towards reducing the residential subsidies. There's been a long history of the residential class being subsidized by other classes, primarily the larger customers, and to the frustration of those customers, understandably. And that movement is, I think, inevitable that those subsidies will be reduced. That's a policy goal, I believe, on the part of the commission, and something that the DOJ will lives with and will work with in future rate cases.
Can you talk a little bit? Dr. Blank yesterday directed us to inquire with you about the history of the class subsidization, specifically the residential class by the others. Do you have any sense of that history?
Yes, yes, I do actually, and in a couple of contexts. First, I've worked for the Department of Justice, who used to be the Attorney General, since 1999, and I've worked on many rate cases for the AG and DOJ's office. Rate cases, I think my first actual rate case for the DOJ was just before 2015, and residential subsidies were very big issues in those cases. But also prior to that, when I was working on other cases for the DOJ, the issue of and the concern of residential subsidies was very much a common dialogue amongst the parties and amongst the people that I've worked with. I've also been at New Mexico State University since 1984, worked with the Center for Public Utilities since 1985. And we put on issues conference and training courses. And in the issues conferences, particularly, the topic of residential subsidies has always come up. All right. And so that dates back to, the 80s. So I believe this is an issue not unique to New Mexico, but for the entire country, that goes back, well into the 80s. And that's where my memory of utility work it basically starts. So a long history.
Yeah, and it's funny. I think when I've been studying the history of this agency, and you can go all the way back to the State Corporation Commission in 1924, and the question at that period of time, of course, we weren't regulating the utilities. We didn't have that authority. This agency, but they were regulating the railroads, and the question was whether or not the people of Tres Piedras should receive a station. And the Supreme Court was very concerned that that would be too much of a subsidization of the other ratepayers for that particular community. So, I mean, you can go back. My sense of it is the history will reveal that with you're dealing with, and I guess this is more of a question than anything for you. I would assume wherever we see large numbers of poor ratepayers, we're likely going to find some degree of subsidization. Is that a fair assessment?
Yeah, I think that's very fair. I think that in areas and states and jurisdictions where you have a high percentage of low-income households, the percent subsidies will tend to be higher. I think even in jurisdictions where you don't have severe poverty, extensive poverty like we have in New Mexico. Yeah, I think the notion of residential subsidies still exists. I talked to some of my friends and in the utility industry in California, in areas of California where you don't face that type of poverty, but still residential subsidies is an issue. So,
Yeah.
but it's more pronounced clearly in areas where you have a high degree of low income.
And it's my perspective, at least from the commission and doing our tasks to the best of our ability, that we be attentive to those matters. And I was trying to have a discussion yesterday with Dr. Pitts, and I hope she understood the discussion we were having. I think she did. Does PNM have a glide path to securing affordability for the large number of low income ratepayers? Or are we looking at a trickle of rate increases out as far as the horizon stretches? And I kind of left that discussion feeling like the answer is we're just going to have a trickle of rate increases out to the horizon. Is that a fair assessment of what she said, do you think?
Yeah, I would agree with that. And in my recent work with the Department of Justice on issues of, what does the future look like, and how burdened are households in New Mexico? Um, I'm afraid that I'm not sure that electricity is going to be affordable for everybody in the future. I think we're going to see a trickle, at least a trickle, if not uh, more than a trickle in terms of rate increases in the future, the foreseeable future, for sure.
Can you and I, for the benefit of so many terms get thrown around in this entire field of practice, and I've heard it before, but the pancaking of rate base increases. Well, that's the sentence that appears in your. Can you just talk about can you define for the record what pancaking of rate cases is?
Yeah, that I look at pancaking, and how I use the term is where you have a relatively frequent amount of rate increases that are kind of piled on top of each other, hence the term pancaking. But since the rate increases are close in duration, that people are still remembering, I just got a rate increase and now I'm going to get another one. And we look at it cumulatively, and it's felt cumulatively. So that's how I view the notion of pancaking, and that's how I see the foreseeable future, Hearing Examiner Ryan, in terms of what we're going to face in New Mexico.
And if I understand correctly, the rates from 22 to 70 were in effect for something like 4 months when this rate case was filed. Is that right?
Yes, I think they were in effect. They actually were in effect at the beginning of 2024, I believe, is when the rates were put into effect, and then a rate case. The application here was filed in June of 2024, and will if the stipulation goes through, then phase 2 will be fully implemented in 2026. So, that's a pretty close amount of time where those rate increases will be put into effect.
Does the commission have any unique challenges in that, as we think about this case, we have the rate increases that are going to be, imposed here, but then we also have the varying riders that exist, just in terms of keeping track of costs. I mean, is there a need for extra vigilance, I suppose, moving forward?
Yes, in fact, I have been working over the last couple months with the Department of Justice in trying to get a feel. I don't believe a lot in crystal balls, but trying to get a feel for, well, what is the next 10 years, next 20 years look like in terms of the average residential customer's bill? And that's a very difficult thing to do, because not only do you have to consider what the base rate increases will be, which occur in rate cases such as this, but also all those riders you speak of. Right now, the revenue, residential revenue, about a quarter of that revenue comes from riders. So a significant chunk. So, trying to look at what are those riders going to look like 10 years from now, 20 years from now. That's very difficult, but it's very germane to the issue of, what's going to happen to bills. I think some of those riders may go away. We have the renewable energy rider, the grid mod rider. When those resources become more status quo, then I think there's going to be pressure to put those into base rates, and those riders will then be eliminated. But still, it's a very difficult thing to do. But the general feel we're getting is, there's going to be increases in this foreseeable future. A lot of investments to meet the green energy requirements, the carbon-free energy requirements put on the utility by the state as state policy, and so that's a constraint, and that's going to involve a lot of new investment. So that's going to cause costs.
It's interesting when you were just talking about the riders and to the extent to which we move into a paradigm where we're thinking about rolling some of these costs into base rates. I guess from an analyst's perspective, partly what you're saying there is, although the legislature statutorily authorized the utilities to utilize riders, that there is need for the commission at some point to say necessarily like the more prudent manner of regulation, given our oversight generally of the utilities function, is to move out of the rider and put it back into base rates, because that's the better model for those types of costs. Is that I hadn't thought of that idea, but that sounds like what you're saying.
Yeah, but particularly and specifically in the environment we're in, when the time period between rate cases is short, which is kind of what I'm seeing now and into the future, every 2 years type of a deal, that the need for riders, I think is diminished, because one of the purpose of riders is to reduce regulatory lag, as an earlier witness pointed out, and regulatory lag being the time period between when the utility incurs the cost and when they get recovery of that cost. And if new costs are coming in and there isn't going to be a new rate case for a while, then you have to, and costs are recovered through base rates, then you have to wait a while to get the recovery. So the rider fixes that. And in situations where there's a long time period between rate cases, that is very advantageous and useful for the utility and for the customers if costs are going down, if they do go down. But now the environment's different. I mean, we're looking at an environment where rate cases, I believe, are going to be a lot more frequent, and therefore the need for riders is diminished. So I agree with what you're saying totally.
The question of the customer charge, you noted in your testimony that the initial application, the increase of the customer charge, which you indicated was about 60%, was too high. And then you write, and this is at page 6 of your STIP direct. Such a large increase limits the control residential customers have over their bills through adjusting usage, because revenues paid via the customer charge are not usage sensitive. And it just struck me when I was reading that, like, it is an odd tension, because on some level, the early adopters of DG, the distributed generation, rooftop solar, they're having very low bills, and it's necessary to ensure that we're collecting their costs through the customer charge, because they're still getting benefit from the system and there are fixed costs still. But then simultaneously, the point you make is a very good one, is that, to the extent to which time varying rates are becoming the standard, then we do need to sort of incent people to change behavior. And the way you do that is by punishing them if they use during certain times. So you do want a lot of it to be volumetric, but just based on time of use. So, I mean, I suppose that the thoughts that maybe had is, do you have a clear sense as to where we're headed in terms of how you do the customer charge versus the usage rates? Like, what's the correct balance?
Yeah, the tension that you describe is very real. I mean, right now, I think in uh, PNM's application, it was noted in a couple places that a full cost customer charge would be about $20. And that's pretty consistent in other rate cases for other utilities that I've worked on, that $20 figure for a full cost customer charge is pretty consistent. And what I mean by full cost is that the customer charge recovers only the customer related cost and all of the customer related cost. Customer related cost being costs that aren't sensitive to usage nor loads. So, it's important that individual customers pay their fair share of those fixed costs, and that's done through the customer charge. So, but on the other hand, you've got the problem for certain households being able to control their bills. So I think the trend is going to be to increase that customer charge. The customer charges have been going up closer to their full cost levels. And in terms of a cost-based benefit, that's a good thing. But then the counter to that, we're going to need more options for the customer to control their bills through the usage sensitive rates, time bearing rates, those kinds of things that can offset that.
It sounds like from your testimony that you're not advocating necessarily, but at least the see the value of continuing to do banding for the foreseeable future. Is that accurate?
Yes. Yeah, yes, it is. Particularly given, but particularly given that the expectation is going to be, frequent rate increases. And so banding is going to be very important. I think there's going to be a push towards increasing the maximum band because on the other hand, there's a push towards reducing the subsidies.
Right.
But I think the notion of the existence of a band is still going to be very important.
So at page 7 of your testimony, you note, and then this is just an established fact, that by the end of phase 2, revenue increases in the stipulation are 19.85% and 6.95% for the residential and small power classes. And I know that was so that's the stipulated resolution, right? And that's a major retreat from where we started in terms of the actual ask and the application. But and I think this is a problem that when hearing examiner Kryenkamp was talking with Ms. Crane, I started to wonder, what do we know about the New Mexico PNM ratepayers' amenability or willingness or capacity to absorb that 20% increase? Like, what do we know? I'm assuming they'll say we cannot afford this, but I mean, do we have any raw data that tells us like this is what's acceptable within these particular income groups that we have existing in the state?
Yes. I mean, clearly people are not going to like the rate increase no matter what it is. But I think that, and working on some of the work that the DOJ has done recently on energy burden, we've done quite a bit of work on trying to determine, what are the number of households in various counties in the utilities jurisdictions that are energy burdened. Energy burden being any household that pays more than 6% of their income towards all their energy. And so I think that is a way to monitor if those energy burdens are increasing, if the number of households that are energy burdened is increasing because of rate increases, then that is definitely something that we need to be paying close attention to. And I know the DOJ is and will be looking at those data.
Is that work that's been done elsewhere in the country that, that we're like sort of utilizing an example of something to understand here's a path forward, or is this something that in New Mexico, like may be a question of first impression? It's an honest question. I don't know I
Yeah,
don't know.
no, the data that I'm working with that has been supplied to me by Gideon Elliott is New Mexico specific and
Okay.
and county specific. We have counties, each of the counties that are in PNM's jurisdiction, service territory. We have information on. I think the data. Um, I don't have the spreadsheets in front of me. Gideon can correct me if I'm wrong, but go back to 2015, I believe, or no, 2020, I believe. And that shows the number of households in each county, the number of households that are energy burdened. And also what we've been working on is what would be the cost in required assistance to lower the energy burden down to 5% for all those households that are currently energy burdened, and try to get an idea of how much would that cost in terms of energy assistance on the part of the state and federal government.
And what are the question I'm trying to ask, and that's all I'm very happy to hear that. I think it's wonderful that you're doing this work. I guess can you look to academic work in other jurisdictions, other utility service territories, and say, well, here's kind of like a similar group of circumstances that we can look at as an example of what to do or what not to do, or are we sort of breaking ground in New Mexico because we have a unique problem? Do you understand my question?
Yeah, no, good, excellent question. And absolutely, there are other states. um, God, I had all that paper stuck away. I believe there's a couple states in the Midwest that we've looked at, Illinois, um, that have energy assistance programs, Colorado. Um, this is being done in other states, and we look to those states as I do in all and have done in all my research. Look to not reinvent the wheel, to look what other folks are doing to kind of guide what is reasonable work in New Mexico. But what's exciting is the New Mexico specific data that I've been given and we're working with, and that's a lot of work. A big shout out to getting Elliot on that. And I'm excited about the work, and I think it's legitimate work that should be done at the Department of Justice.
Terrific. Go on to page 8 of your STIP testimony. At the top of the page there, you write, and I just want to get clarification on what this means. The stipulation proposes that the rate increases for most of the rate classes, including residential and small power, will be spread pro rata across each rate class's base rate elements. And I'm wondering, could you just help me understand that pro rata, unpack that a little bit?
Oh, sure.
Yeah.
Yeah, absolutely. And this is, I believe this is also shown in a spreadsheet in Dr. Pitts's response to the bench request in PNM's exhibit HMP2 that shows all the increases. And basically what the prorata does is, since the residential class, for example, received a 19.85% overall base revenue increase, then all the individual rate elements then would also be increased by 19.85%.
Okay.
That's what the pro rata means. But you'll also note that a couple of the rates, most notably the block 3 rates, which is the high usage block, had to be increased a little bit more than the 19.85%, and that was to recover money for the residential class's fair share of the cost of the incremental interruptible power rate. Okay, so you'll see that one exception, but in general, the pro rata increases just simply increase all the rate elements by the same percentage as the overall base revenue increase that the residential class faced.
And I guess, just hearing you speak there about the sort of block rate structure, we're still living in a world in which that's necessary because, I mean, the block structure, because we're not at a point where we have the pilot program, AMI is being rolled out, but in reality, we're still sort of living under former circumstances at this point.
Yes, and I think putting the recovery of that incremental interruptible rate, power rate, the residential fair share of that, in the block 3 rate is makes sense, because that way because since block 3 starts at 900 kilowatt hours, the average customer at 600 kilowatt hours doesn't see that.
Right.
Okay, because they're not on the third block. So I think that was a good move to try to mitigate the impacts on the average residential household.
This is really just a very general question, but I've often thought to myself, like, we have as power users, I think, been conditioned to understand the correlation between amount consumed and price, and we are now moving into a paradigm whereby it is not a question of how much, but when, and that is a fundamentally strange concept for ratepayers to embrace, and it will take a lot of time. And do you think there's sufficient outreach to ratepayers at this juncture to sort of begin the groundwork for that paradigm?
I think that outreach is just begun, and there's a lot more. There will be a lot more work on that. Historically, in my research that I found, most residential customers don't respond to what we call the marginal price. Okay, the price for the next kilowatt hour during the next hour, say. They respond more to the total bill. All right. So, the total bill is, it includes everything. So if my bill goes up, then I'm going to respond to that by trying to reduce my consumption. When I do that, or how I do that is not as detailed in the customer's analysis. But I think that's changing. And there's always going to be customers that are excited about getting this new information that AMI has to offer, and be more of be more in tune to the marginal price and the price in a particular hour. But then there's always going to be a certain amount of the households that just simply look at the total bill. I think that will be a relic that will remain.
You indicated it in your page 9. You were preparing your potential direct testimony, and you were considering a maximum band somewhere between 130 to 150% and a minimum of between 70 and 50%. How did why those numbers, out of curiosity?
Right. A couple things. I was trying to stick with the notion that the higher the overall rate increase is, all right, in a case, so the higher that percentage increase is, the lower would be the maximum band, and vice versa. For cases where the overall base revenue increase is relatively low, then that affords the opportunity to increase that upper band and reduce the subsidies. In PNM's prior case, the rate increase was a little over 2%. All right. In the last case, the case where the rates were put into effect in 2024, there was a little over 2% overall increase in the final order. And in that final order, they also had a relatively high upper band of 175%. I thought that applying 175% band in this case would not be appropriate because the overall rate increase was what was substantially higher.
Can
All
I ask you,
right.
was that substantially higher? My understanding, and I believe this was from a newspaper article that came out around the time of the filing, this filing was the largest requested rate increase for the residential class in the company's history. Is that, am I saying something that's inaccurate?
That's my understanding. Okay. That was it's higher than anyone. I've worked on PNM rate cases since 2015, and it's higher than any of the ones that I've worked on. But the overall stipulated increase was 13.8%. Okay, so and as Andrea Crane mentioned earlier, the preliminary numbers that she was working on, given her adjustments and the adjustments that she thought would fly, was very similar to the 105 million that increase you see in the stipulation. So I knew that ahead of time. I work in close conjunction with Andrea Crane. She does revenue requirements. So during the process of putting together our initial analyses and initial recommendations, we're working closely together. And by the way, it's been an absolute joy and privilege to have worked with her. So I just, my own personal shout out to Ms. Crane and how much I've learned from her. I really appreciate it, and she's going to be sorely missed. I will sorely miss working with her. But given how her numbers were coming down, I knew that 175% would be too high. And so I looked towards some of the past cases, particularly there was a case, the 2015 case, which had a similar rate increase. And that band came down to about 130, 140%. So that's why I was kind of looking at the 130 to 150. I was playing around with going up to 150% because I knew there would be pressure to eliminate the residential subsidies, at least to some degree. All right. So I kept that in mind in my analysis. So the stipulation.
Yeah, go ahead. Sorry, I didn't mean to cut you off.
I'm sorry. So the stipulations maximum turned out to, if you, after the fact, as you were talking about yesterday, figure out what does that imply about what a ban would be. That was that 143% ban that Dr. Pitts talked about. That was right in kind of the middle of the range I was looking at, applying to Andrea Crane's percent increase overall.
At page 13, you indicate that the residential 1A/B service class is a subsidized class and receives a $40.8 million subsidy. That's what I understand to be under the stipulation. And my question is, we spoke earlier about, wherever we're going to find, low income ratepayers, we're likely going to also detect some sort of subsidy. So when a commission sees that number, is that something that's surprising, or is that relatively, unsurprising, I guess is the only way I don't know. Should we? Yeah, go ahead.
I think it's unsurprising in the extent when you compare to past commission orders and results of past cases, both PNM's case, which I've outlined on page 16 of my testimony, and other utilities, El Paso Electric, Southwestern Public Service. But the trend is a decrease in the subsidies. All right, and 9.26% increase in this case is a decrease from the last case, and is also a decrease from the average of the previous two cases. So, and it's in the ballpark of what those other percent subsidies were, with a slight downward trend. So that doesn't surprise me. I think it's reasonable.
Last question for you. Page. Well, I appreciate the chart. I will just say that, but since it's not a question, the chart that you supplied at page 16 is super useful. And when I came across it, was looking at it, I thought that was wonderful that you did that. So thank you.
Thank
And
you,
then,
sir.
yeah, then on page, the concluding question, page 14, you write there in that paragraph, this is sort of down towards maybe the middle bottom of the page. The NMDOJ has emphasized gradualism and the mitigation of rate shock, noting that the residential customers are finding it increasingly difficult to juggle their energy costs with other demands within their tight budgets. And, that we've talked about this a little bit, and I don't need you to repeat any of what you've said already, but I mean, on some level, it seems to me that you're here on an unopposed stipulation on where everybody agrees on all these things. And I think the question for the commission ultimately becomes, how does this case fit into whatever larger trajectory we have here? And I don't know that I've yet heard what the broader trajectory is to achieve the goals that you're saying exist as a tension right here. And I guess I'll just give you an opportunity to offer any final thoughts about that subject.
Are you referring to the affordability issue
Yeah.
absolutely.
What's the future for the PNM ratepayer to make sure that they're going to be able to adequately juggle that? And because, if they fail the juggling episode, what it means is people's lives, becoming very difficult.
Yes, I think it's going to be become more difficult. Unfortunately, I don't see an optimistic future, but that's why I think it's very important to keep an eye on what's happening to the household energy burdens. All right, because the energy burden is a good summary of that juggling of your budget and how much is being paid on energy overall. And uh, to the degree that those energy burdens are increasing, then I think what's required is a social policy on the part of the New Mexico legislature to offer increased energy assistance to decrease those energy burdens. I don't think the ratepayer funded subsidies is I've never liked those. I've always uh, um, moved more towards taxpayer funded subsidies and assistance because it's a social policy, and the people should be able to vote on whether any movement in the legislature is good policy or bad policy. I mean, we should have, taxation with representation. And I, but I do believe that there's going to be more pressure to get more assistance and get assistance from the state to augment the low income energy assistance that New Mexico currently gets from the federal government. How much is needed, I think, is then determined by the analyses of keeping an eye on what's happening to those energy burdens and what would it cost to reduce those energy burdens.
Very good. And that's all my questions, Dr. Gigax, and I would commend you also on your contribution to our cases. And I always advocate in our commission to have greater connections between this agency and NMSU and the CPU. So I think it's a very unique thing that we have these centers of a center of learning in our state on these subjects, and the commission should be as engaged with you all as we possibly can, and as much as you'd like us to be.
Yeah, no, and I appreciate all your personal support of our programs as well, Commissioner Ryan. It's much appreciated.
Thank you. That's all my questions, Hearing Examiner Brian Kemp.
Thank you. Good morning, Mr. Gigax.
Good morning, Hearing Examiner Brian Kemp.
Most of my questions you've already answered. I do just want to circle back on a couple of items.
Sure.
Like Hearing Examiner Ryan was asking you about earlier yesterday when we spoke to Dr. Blank, also of NMSU. He directed us to you to ask you a little bit about the history of these class subsidies. And there were just two other questions that I had regarding that history that I wanted to pose to you. And, I don't know how, you may not know the answers to these questions, but, one question that did come to mind, as, you were talking a little bit about the history of these class subsidies and, especially that they're more frequent, I guess, in poorer states. What were the regulatory principles that New Mexico would have relied on, or these other commissions would have relied on when they agreed to these class subsidies in the first place? One of the questions that hearing examiner Ryan and I have to address as part of any stipulation is whether that stipulation is consistent with established regulatory principles. And so given that, we have this movement towards cost-based rates, that begs the question, what regulatory principles were they relying on back in the day when these subsidies sort of first got rolling?
Right, good question. I look at the work done by Professor Bonbright, and his book is referenced quite a bit. I don't have the publication date, but he has a number of criteria of a sound rate design. Okay, and I believe that first came out in the 40s. I'm not sure. It's subject to check. But that's kind of where this discussion started about, well, what are all the objectives that we're trying to satisfy with our rate design? And one of those was the avoidance of rate shock, rate stability. Okay, and that stuck. Okay, there are a whole host of other ones there, but the one involving the avoidance of rate shock and rates should be stable through time. Okay, that has been interpreted as meaning, well, no huge big jumps in rates, and that stuck. And I think that's kind of was the beginning of this emphasis on, well, we know that, and one of his other principles was rates should be reflect cost. So those two are there's a tension between those two, and so that's, I think, what we've been battling for a long time, and has come to be kind of a bedrock in terms of those regulatory principles that you are referencing. I think those are key, and balancing those two, and to what degree we balance those two is gets fought during the rate case. And you have classes in New Mexico that have been the subsidizing classes for a long time, and understandably they're frustrated with that. That's why I was really happy to see the large customers who would have gotten significant rate decreases if we move towards cost were willing to put up with a close to 7% increase. That showed sincere willingness to give and take, and that's why this thing worked. All right, but no one's happy with subsidizing other people, and that's understandable.
Sure. No, and that makes sense. The background to that is very helpful to me. And the other question that came to mind, and I think you sort of already answered this in your previous answer, but the question was, we've heard a lot in this proceeding about gradualism and moving towards a more cost-based rate. Has that same sort of push been there for as long as these subsidies have been around, or is that more of a newer phenomenon where we're actively trying to move in that direction sort of with every rate case?
Right. Yeah. Excellent question. I think that there's always been this push towards, well, let's reduce the subsidies. Let's reduce the subsidies. And then the subsidizing class is saying, well, yeah, we're kind of moving at a glacier pace, right? Can we speed it up a little bit? So I think it's the phenomenon of actually doing something about it, and trying to put a real cut into those subsidies is relatively new. Maybe goes back to 2010, around there. But this issue of when are we going to start whittling away at the subsidies, that's been around as long as I've been working in this field.
I ask you one follow-up question on that subject, and basically the question I want to ask you, Dr. Gigax, is and it sounds like, I think this is, I'm asking more for confirmation than anything, but to the extent to which you're saying that the movement towards cost-based rates is beneficial, is effectively the argument that the commission would do well to figure out the mechanism outside of, not the commission can do this, but like to work with whatever stakeholders are necessary, that could be our legislature or wherever, to achieve the cost-based rates outside of rate setting, and that would be a social good that's useful to all participants in these rate cases.
I couldn't put it any better. I totally agree. All
Okay.
right. And that's why it's important to know what the cost-based numbers are. Okay, and that serves as a benchmark. And as has been mentioned both by Andrea Crane and Larry Blank earlier, that witnesses, experts can disagree on what allocation method to use. All right, but generally there's a close range of reasonable outcomes that people can agree on. And we look at the utilities cost of service study, class cost of service study is kind of a benchmark, because that way we can quantify the subsidies, right? We can compare the actual revenues distributed to a class to what their full cost revenues. So the transparencies are the subsidies, excuse me, are transparent. And that's absolutely a good thing, because then that tells us what we're working with and what we have to do in the future if we want to mitigate those rate impacts.
Thank you.
And let me follow up with you on another subject in your testimony. You also talked about I forget exactly what the question was from hearing examiner Ryan, but you answered it by saying that you would prefer, I guess, more of a legislative solution to assisting lower income ratepayers rather than I guess sort of a rate-based approach. And your answer to that was essentially that this was a social policy, and to that extent, the legislature is probably the proper entity to decide it. And in another case, another proceeding, I heard a witness from DOJ explain that essentially electric rates are a little bit more regressive than taxation, which is more progressive in New Mexico. And she was making, I think, a similar point about a different type of social policy. Would that also factor into your answer as to why, addressing cost is better situated at the legislative level?
Yeah, that would be I haven't given that a lot of thought, but now that you mentioned, I think that's an excellent point. In the case of electric rates, it is regressive. I mean, lower income households pay a higher percent of their income on energy. All right, and higher incomes pay a less percentage. I mean, that's progressive. If you look at the rates as kind of a tax, and so that would be another benefit of having the taxpayers subsidize the energy assistance. Also, I think the utility and the interveners in case they already have tons of things on their plate. The utility has, although there's a lot of tension between the interveners and the utility, I appreciate how much work the utility has to go through, how many things are on its plate. And to throw another, something as important as low income assistance on the utility's plate in addition is I'm afraid might just end up being kind of an afterthought because there's just too many other things. All right. I just think it's a lot better, for the legislature to step up and say, well, if we care about low income households, if we really do care, then let's do something about it. And let's increase the energy assistance and reduce those energy burdens, which right now, based on the data that I've been given, almost 25% of the households in New Mexico are energy burdened. That is to say, they spend 6% of their income on energy or more. And, that's a real issue. And that's a state issue that that needs to be solved at the state level, in my opinion.
And maybe, so I just want to follow up on that thought too. I mean, so maybe Professor, can you talk about, there's often we hear economic development. And I think if I understood from what Dr. Blank was saying yesterday, when the city of Albuquerque thinks about its economy, it has to think about what percentage of the its citizenry are paying towards things. And if you've dedicated large numbers towards residential energy costs, and you can't put that money into other things. So in many ways, it is an economic development issue. Is that correct?
Yes, and that's why I think that understandably, large customers are very sensitive and concerned about the degree of the subsidies that they're paying to the subsidized classes. All right, that increases their costs. That makes them and their business enterprises less competitive with other alternatives, and is hinders economic development. So those are real issues, and I understand those.
But I think my point was too, is I'm just curious your thought on this, is like, when we think about the residential class as a whole, obviously those people do things with their money other than pay it towards they go out, they enjoy, right? So if you're dedicating less money to just figuring out ways to free up money within residential classes that they could spend in their local communities, that is economic development.
Yes, you're absolutely right. That's an excellent point. I totally agree.
Thank you.
And Dr. Gigax, let me ask you about another type of, I guess, what can be labeled a subsidy. Let me ask you again about that customer charge
Right.
in the for residential customers. And I am looking in particular at page 8 of your testimony. And you talked a little bit about why the significantly lower customer charge better enables residential customers to control their own bill, while also mitigating the impacts on lower usage customers. This would be another type of subsidy, wouldn't it? I mean, certain residential customers would end up subsidizing other customers within that rate class.
Absolutely. You're talking about an intra-class subsidy. And when the customer charge is not at full cost, then you have to then recover those customer-related costs, those fixed costs, through revenue recovered through the energy charge. And so what that means is that above average users are going to contribute more to those fixed costs than below average users. So those below average users are being subsidized then by the above average users.
Right. And, but with respect to the customer charge, those are fixed costs that are the same, whether you're a high usage customer or a lower usage customer, right? So help me understand the theory behind why it would be reasonable for the higher usage customers in that instance to subsidize the lower usage customers when those particular costs are the same between those two subsections of the same rate paying class.
Right. I was just commenting that it is a subsidy. I was just acknowledging that a subsidy does exist whenever the customer charge is below cost.
Right.
Whether that's a good thing or a bad thing, I think to the degree, I think there was a train of thought, a school of thought, if you will, in the past, that low usage means low income. All right. And if that's the case, then your higher customer charge definitely hits more than proportionally the lower usage customers. And if those customers are also low income, then that hits more than proportionally the low income groups. All right. Which, there's more pushback to that. All right. There's a whole host of reasons why you might be low usage. I think some of the more recent research is casting some doubt on that in terms of low income households definitely are not high usage households, but they tend not to be extremely low usage either. They tend to bunch around the average in the studies that I've seen. And the studies that was in were in the PNM application. But so that's I think that's where that came from. All right, the concern. I think you also have to consider things like, well, low income households tend not to be as energy efficient than as high income households. Also, low usage households. So that would make low income households use more energy. Also, low usage households are not necessarily low income. They could be households that have invested in distributed energy, distributed generation, rooftop solar, all right, which, low income households typically do not make those type of investments. Um, Households that have maybe don't have children, maybe a single person living there that works a lot, is away from the home. There's a whole host of reasons why a household could be low usage other than it being low income. But I think that connection is why we have historically viewed concern about impacts on low usage households as being a concern.
I don't mean to get interjecting, but it's a very fascinating conversation. I've greatly enjoyed this. And I was just thinking to myself, the New Mexico housing stock, if you talk to people who move here, and I do frequently, or whatever I'm doing, you meet someone who's moved here, and they're always sort of astonished at the lack of quality in the housing stock. And I think what they're generally referring to is, that there's a lot of homes built in a period of time in the state when, efficiency wasn't the primary consideration. And you think about sort of historic preservation issues, and some of these state buildings you walk into and the windows are just, and I actually wondering, like, if you could look and sort of correlate historical preservation with energy consumption and efficiency and try to find some sort of, perverse incentive that exists there.
Yeah, absolutely.
Yeah, I'm still wondering about, one of the statements that you had made in your testimony. I'm looking at page 6. Again, staying on the subject of the customer charge, was that you felt that PNM's initial proposal to increase the fixed monthly customer charge by 60% was too high. And I'm wondering, is that because you think that there is a link of some sort between income level and usage level? I'm struggling to understand, I
Sure.
guess,
Yeah.
because I understood your previous answer to say there are essentially different arguments you can make about the merits of, a lower versus a higher customer charge, and that there's a certain amount of question as to whether or not there is a correlation between income level and usage level. So if you could just clarify, I guess,
Sure.
your take on PNM's initial proposal.
Yeah, I just thought it was too big of it was a drastic change in that rate element. All right, so I was more looking at that rate should be relatively stable through time. I was looking at that objective, and which means that individual rate elements, there shouldn't be a dramatic increase. Dr. Blank yesterday talked about overall revenue increases of 25% or greater as he becomes very nervous about that, and as do I. All right, that's definitely rate shock. But you can apply those type of percentages to individual rate elements as well. So if you have an individual rate element that's increasing 60%, I would call that rate shock also. So I think my concern in that statement in my testimony was more towards not the low usage, low income issue, but more the rate shock issue.
Okay, that's helpful. And then one last question, I guess that comes to mind, just as long as we're talking about subsidies within different classes and I guess cost sort of allocation between different types of charges. The lack of a demand charge, and I know that a demand charge is unusual for at least for the residential class. To an extent, could that also be seen as a subsidy of a sort?
Well, because the demand charge, in a perfect world, the demand charge would be used to recover the demand related cost or the capacity costs. All right. And capacity costs are sensitive to loads that are put on the system, right? Okay. So if you don't have a demand charge, then that means those demand related costs, which are also viewed as fixed cost, have to be recovered somewhere. And they're not going to be recovered in general through the customer charge, because the customer charge isn't even recovering 100% of the customer related cost.
Right.
So what that means is the demand related costs therefore are being recovered, as well as a significant portion of the fixed customer charge through the energy charges. So you're absolutely right. There again, you get to the fact that the average usage customer is contributing the average level of fixed cost owed to the residential class. Above average customers, since so much of that recovery is tied into the energy charge, the above average customer is contributing more than average. Okay, or you could say, I guess, more than their fair share, in a sense. All right. That's because, again, the energy charges are recovering so many of those fixed costs, demand related and customer related. So the argument is true to that too. You're absolutely correct.
Can I ask for a point of clarification? You know, this comes up in the context the hearing examiner Kreinkamp and I had the EPE time varying rate pilot program case, and there they were they're having one of the treatment cells for that case was a demand charge in a time varying rate. And I just want to make sure that I'm not confused or that I understand correctly. If we think about the residential classes aggregate demand, I guess we call that the coincident peak. I mean, that is like the capacity question, right? So if everybody is demanding electricity at the same moment, we create a capacity level that must be met. And are you saying that is itself really a fixed charge question?
Yeah. Once the investments are made, then the capital cost associated with those investments are fixed. They're fixed in that they don't vary with kilowatt hour usage. All right. That's kind of the common definition of a fixed cost in this industry, is costs that do and costs that don't vary with kilowatt hours. And in the short run, meaning once those investments are made, then those costs are fixed. In the planning horizon, which is what you do in IRPs, those capacity costs are variable because you're planning what they should be, right? So that's a different time horizon. I don't know if that answered your question here in examining Ryan.
Well, I guess sort of. I mean, I guess my question is like when we think about, I mean, because in that case, it was interesting that they were proposing, the residential classes don't generally have demand charges, right? And this was for a residential class. And so we had a lengthy discussion in that case about whether or not it's appropriate to sort of apply demand charges to residential rates. And then what I understood, and again, I'm just asking for clarification more than anything, is, if we think about aggregate demand, like the full, coincident peak of the system use, is that like itself correct to be thinking about as a charge that's fixed, because we have to supply that amount of electricity to the entire consuming public, and that has itself a fixed cost at a coincident peak.
That's correct. Now, one of the problems with how demand charges are implemented is that the demand charge rate, that dollar per kW rate, is typically applied to the customer's non-coincidental peak demand over the course of the month. Okay. All right. And that has long been criticized by economists as not the appropriate way to apply the demand charge. Should be applied, the argument is that it should be applied to the customer's coincidental peak load. All right, because it's the coincidental peak that's driving most of those capacity needs. All right, now with AMI, we can actually, with the rollout of that, we'll be able to do that better in terms of measuring that. I mean, we can do it now with time of use meters, but that has been a criticism of the demand charge. There are jurisdictions that have residential demand charges. The most notable one that comes to my mind is Arizona Public Service. It's an option. It's not a pilot. It's an actual optional rate.
Thank you.
Thank you, Dr. Gigax. I'm sure I speak for hearing examiner Ryan and myself saying this was a fabulous discussion, and we really appreciate you coming in to testify. I don't have any further questions for you, sir.
Again, I'm sorry about my throat. I had esophagus and stomach surgery on Thursday, and my throat is still suffering from that. So I pardon my throat clearing.
Oh, no worries at all. Came through loud and clear, and it was really fabulous. Let's see, Assistant Attorney General Elliott, any questions on redirect, sir?
No, only thank you, Dr. Gigax, for being here very much.
You're
Yes,
welcome.
thank you.
And thank you all for all your work.
Thank you. Any further questions from anyone for Dr. Gigax? Okay, seeing none. Again, thank you so much, Dr. Gigax. You are excused, sir. Thank you.
Hey, thank you.
Hearing examiner Krankamp, my colleague Jocelyn Barrett and I would request to be excused for this afternoon.
Yes, absolutely.
Okay, thank you.
That request is granted. Let's see. So, hearing examiner Ryan, well, let me ask Mr. Lee. Mr. Lee, can we finish one more witness before we go to lunch, or do you need a break
Certainly.
now? Okay.
Certainly.
All right. I think we can finish. I think we had Ms. Zuer. Thank you for turning your camera on. I think we had your witness up next. Mr. Barnes?
Yes, thank you. Coalition for Community Solar Access calls Justin Barnes.
Okay, thank you. Mr. Lee, if you'll please swear in the witness.
Mr. Barnes, will you please raise your right hand? You solemnly swear the testimony you're about to give in the matter now pending should be the truth, the whole truth, and nothing but the truth?
It will be.
Thank you.
Thank you. Go ahead, Ms. Zuer.
Good morning, Mr. Barnes. Could you please state your full name and employment for the record?
My name is Justin Robert Barnes. I'm the president of EQ Research, LLC.
On whose behalf are you testifying?
I'm testifying on behalf of the Coalition for Community Solar Access.
Do you have CCSA, that's Coalition for Community Solar Access, exhibit number 1 in front of you?
Yes, I do.
Could you please identify it?
This is my testimony in support of the settlement on behalf of CCSA.
Was it prepared by you or under your direction?
Yes, it was.
Do you have any corrections to make?
I have no corrections.
Is it true and accurate to the best of your knowledge and belief?
Yes, it is.
If I asked you the same questions today, would your answers be the same?
They would.
With that, I move to admit CCSA Exhibit 1.
Thank you very much. Pursuant to the stipulation, there's no objection. So CCSA, I'm sorry, Exhibit 1 will be admitted into the record.
Thank you. With that, I pass the witness.
Thank you. Let's see. Going to the commission first, and I think, Mr. Chair, I think you're first up. Do you have any questions for Mr. Barnes? Chair O'Connell?
Yeah, thank you for the opportunity. I don't have any questions for this witness.
Okay, no problem. I don't see any other members of the commission on right now. Hearing examiner Ryan, do you have any questions for Mr. Barnes?
Just a single question. Mr. Barnes, at page 6 of your stipulation testimony, lines 4 through 12. I won't read all that just for the benefit of our court reporter, because if I read the words, he's got to type them out. So that's what I really would like there is I'm trying to understand what it is that you're attempting to convey in that paragraph, and would ask that you help me understand what is written there. And I apologize that I can't tell you, like, I need you to tell me this. I'm just trying to make sure that I understand what this paragraph is attempting to communicate, and want to give you the opportunity to clarify.
Sure. So we've obviously, I've been on for at least this morning, and we've been talking about kind of the differences between cost-based revenue requirements and the revenue requirements adopted in the stipulation, which are different than what are implied by the cost of service study. And the differences, differ by rate class, right? So for the residential class, the adopted, or what would be the adopted revenue requirement, or the stipulated revenue requirement, is a certain percentage below what the cost of service revenue requirement would be. And in this discussion that I have on page 6, what I'm saying is that, let's just call it a 10% difference. I don't recall the specific number. Let's say that 10% difference, it doesn't have any, it's kind of a catch-all that encompasses all utility functions: generation, transmission, distribution, customer costs. It's not specific to any function. It's just a number. And when I say that this kind of even functional apportionment maintains the proportionality of the cost of service study, what I'm really saying is that each of those individual components, with that 10% reduction in a class's revenue requirement, or 10% increase for that matter, moves in equal proportion. So generation component goes down by 10%, distribution component goes down by 10%, or upwards, depending on the rate class. And in that way, if, let's say, the distribution portion of a class's cost of service revenue requirement before the stipulation was, say, 25% of the total retail rate, after the stipulation, that distribution portion will also still be 25% of the retail rate. It just kind of maintains the same ratios between functions.
Okay. Thank you. That helps me. That was the only question I had for Mr. Barnes, hearing examiner Brian Kim.
Thank you. And Mr. Barnes, I just want to pick up, I guess, right where you left off. And I think I'm understanding the point that your testimony is making. Can you just better clarify for me, I guess, CSA's interest overall, I guess, in the proceeding, and how that applies to the distribution function of service?
Sure. Well, the context for that is that the community solar credit rate for subscribers is the volumetric, it starts with basically the volumetric equivalent of the retail rate, incorporating all functions. And then to actually get to the subscriber credit rate, you exclude a customer component and you exclude a distribution component. And the reason CCSA is interested in this functionalization question is because what we want to see is that if you change the overall class revenue requirement by some proportion, you change all of the individual components of that retail revenue requirement by the same proportion, so that distribution exclusion, if the class rates, retail rates, are 10% lower than what they would otherwise be, then that distribution component is also equivalently 10% lower than what it would otherwise be if you had just maintained the kind of equivalent volumetric rate from the cost of service study. And that's what I kind of mean by the tether, is that we're changing the retail rates when we make these revenue adjustments. From the standpoint of the community solar credit, we want to make sure that those components that get excluded are also adjusted accordingly, in equivalent proportion, because these changes in the revenue requirement are not specific to distribution or customer or generation or transmission. They're just money.
Okay, that makes sense. Okay, That makes sense to me. Thank you very much. I don't know that I have any further questions for you. Hearing examiner Ryan, anything further?
No, thank you.
Okay. Ms. Zur, any questions on redirect?
No, but thank you for the opportunity.
Thank you. Any remaining questions from anyone on the call for Mr. Barnes? Okay, seeing none. With that, thank you very much for your testimony, Mr. Barnes, and for making time to be with us this morning.
Thank you as well, hearing examiners and commissioners.
Thank you. You're excused. Okay. Hearing examiner Ryan, what's your pleasure? It's
I say
you
take
want-
lunch. Let's
Okay.
just do
Okay.
That's my view. Let's
Okay.
take a bit of a, and it's not just lunch. I'm ready for a break.
Okay, that sounds good.
So then
You
just for
wanna-
clarity, yeah, sorry, we'll just, so we'll have, when we get back, and I didn't mean to cut you off there. I'm just, was to go real quickly. It'll be Mr. Andrews, Mr. Bieber, McGovern, Leyba, Jimenez. Is that the idea?
I think so, yes. So let's put that, Mr. Gould, if we come back at, let's say 12:45, would Mr. Andrews be available?
He will be, yes.
Okay,
Perfect.
excellent. And for any of the other parties, are we aware of any conflicts that would arise if your witnesses are taken in that order this afternoon?
This is Kurt Bain with Kroger. No, Mr. Bieber is ready to go.
Excellent. Okay, thank you all. So we'll be back at 12:45, and for now, we'll be off the record. Afternoon, Mr. Lee.
Good afternoon. I'm ready when you are.
Okay, sounds good. Give it another minute or so.
Can't stand the anticipation.
I know the feeling.
Mr. Krankamp, I am not able to start my video, and there's a message that says cannot start your video because the host has stopped it.
Oh, that wouldn't have been me. So I think what I noticed, Mr. Gould, you left your video on during the break, and
Okay, sorry
you
about
see
that.
all kinds of crazy people forgetting to turn their videos off, and then they do stuff around their house, or like.
Well, with me in particular, yeah, I was running around the house.
I just do it as a precaution to you all as a service.
You know what all my laundry looks like now.
All right. I think we're ready to resume. Mr. Lee, whenever you're ready.
Go ahead.
Okay. Well, the time is now 12:45. Thank you all for being back. We're back on the record. And I believe where we left off was NM area. Mr. Gould, you were going to call your first and only witness.
Yes, NM area calls Brian Andrews. Mr. Lee, could you swear in Mr. Andrews?
Yes, sir. Mr. Andrews, would you please raise your right hand? You solemnly swear the testimony you're about to give, no matter no opinion, should be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you, sir.
Mr. Andrews, could you state your full name and your business address for the record, please?
My name is Brian C. Andrews. My business address is 16690 Swingley Ridge Road, Suite 140, Chesterfield, Missouri, 63017.
And who are you employed by?
My firm is Brubaker and Associates.
And why were you hired by NM area in this proceeding?
My firm was retained by NM area to evaluate PNM's rate request and to advocate for their interest in this proceeding.
So you are familiar with PNM's application in this case?
Yes, I am.
And I take it that you are also familiar with the filed unopposed stipulation in this case?
Yes, I am.
You have in front of you a document that's marked for identification as NM Area Exhibit Number 1. Could you identify that document, please?
Yes, this is my direct testimony in support of the unopposed comprehensive stipulation in this proceeding.
And that is dated January 10th, 2025, is it not?
Yes, it is.
Do you have any substantive changes to make to that document?
I do not.
If you were asked the same questions today as you were asked in that testimony, would your responses be the same?
Yes, they would.
And to the best of your knowledge, are those responses still true and correct today?
Yes, they are.
Mr. Hearing Examiner, I would ask for the admittance of NM area Exhibit Number 1 pursuant to the STIP, and I pass Mr. Andrews for further questions from you and any of the commissioners.
Thank you, Mr. Gould. Pursuant to the stipulation, there being no objection to the admission of NM area Exhibit 1, it is so admitted. And with that, let's see. I see that Chair O'Connell, looks like you're the only commissioner on. Do you have any questions for Mr. Andrews?
No, I appreciate the testimony provided and don't have any questions.
Okay, sounds good. Hearing Examiner Ryan?
Just a few questions. We've gotten to the point. We've exhausted a lot of these subjects. So, Mr. Andrews, I won't belabor the point. From NM area's position, were they as surprised by the pancaking of the rate cases as Dr. Gigax described? I mean, you have a section of your testimony when page 5, NM area's members were very concerned that PNM was before the commission so soon. after the resolution of the last rate case, requesting another revenue increase. Can you expand upon that a little bit?
It was surprising, sort of, based on the outcome of the previous rate case. We kind of knew that another rate case, this rate case, was forthcoming. The size of the requested increase was a bit surprising. Especially since the rates went into effect just January of 2024, and then they filed for the new rate case. I believe it was June in 2024. So it was a quick turnaround for a new rate case.
The decrease in the subsidies that'll be going from the rate schedules of the type the customers for NM area represents to the residential classes, it's decreasing. I presume NM area's position and that is that's a good thing, and maybe I mean, we've heard a lot of testimony in this case, and I'm not sure if you've heard it all, but I would just ask you as NM area's witness, what is the position on subsidies, and why is it good that the commission is moving towards parity or unity in the cost of service?
It's NM area's position and mine as well that allocation of costs and rate making should be based on the class cost of service study. There's a number of different reasons why we cannot just set rates based on the exact results of the class cost of service study. Rate shock, gradualism, rate stability, those are all reasons why we just can't jump into fully cost-based rates at this time. As I said in my testimony, the residential subsidy in the last rate case that was approved was about $48 million. And the stipulation here would reduce that subsidy to about $40 million. So from our perspective, we believe that the reduction of subsidies is moving in the right direction.
And then what are the tangible benefits that come, apart from savings, I suppose? I mean, does the type of customers NM area represents, what do they hope to see as a result of that? I mean, what do they expect to see?
They ultimately would like to see fully cost-based rates, but we have to operate in the environment that we are in, and we understand that getting there cannot happen in a single rate case. So PNM continues to file rate cases regularly. In the future, we can continue to reduce any subsidies that exist within the rate classes.
All right. I won't push on those matters further, Mr. Andrews. We've heard a lot of testimony already in this case, and I've read your testimony, and I understand the position of NM area. So thank you, sir.
Thank you.
Good afternoon, Mr. Andrews.
Good afternoon, hearing examiner.
I was going to ask you as well about those rate making principles and the idea of gradualism, but given that line of questioning from my fellow hearing examiner, I won't pursue that. I did just want to ask you, I was noticing on page 12 of the stipulation, sort of the differing impacts of the stipulation on, I guess, the various members of NM area, depending on the rate schedule at which they take service. And one of the topics that we've explored with some of the other witnesses, in particular the city of Albuquerque and the NMDOJ as well, is sort of the internal balancing that they go through as part of formulating their own litigation positions and then ultimately their position in a settlement. And given that it's clear, I think, from your testimony that NM area's members are also, not monolithic. I was wondering if you would speak a little bit to how you go about balancing the interests of your members and the affected customer classes when you participate in a case like this.
Yeah, so we were hired by NM Area. The firm was to evaluate the case in its entirety, with focus on the rates under which NM Area takes service, which are 4B, 15B, 30B, 35B, 36B. And so the revenue requirement reductions that we would have looked at would benefit not only those customers, but the entire system, all of PNM's customer classes. And then in terms of helping just those customers that NM Area represents, we would look at the class cost of service study and the banding issues in the case and attempt to recommend a revenue distribution that would move the classes closer to their cost of service and to reduce subsidies further. And then finally, after revenue allocation is taken care of, then we would go into the rate design phase to ensure that as much as possible, each rate component within the rates are also based on the class cost of service study.
Okay. Thank you.
Yes, thank you.
I don't believe I have any further questions for you, unless Hearing Examiner Ryan, that spurred any questions from you. Okay. Mr. Gould, any questions on redirect, sir?
I have no questions on redirect, and I'm going to shift my participation over to the YouTube link.
Okay,
If
no
that
problem.
would be okay with you, Mr. Hearing Examiner.
Absolutely, no problem. Thank you, Mr. Andrews, for your testimony. It is greatly appreciated.
Yes, thank you, Mr. Hearing Examiners.
Thank you. Okay, let's see. I think that brings us now to Kroger.
Thank you, Mr. Hearing Examiner. Kroger calls Justin Bieber.
Okay. Mr. Lee, if you would please swear in Mr. Bieber.
Mr. Bieber, would you please raise your right hand? You solemnly swear the testimony you're about to give, no matter not pending, should be the truth, the whole truth, nothing but the truth?
Yes, I do.
Thank you, sir.
Thank you. Mr. Bieber, can you please state your name and employment for the record?
Yes, my name is Justin Bieber, and I'm a principal with Energy Strategies.
Did you submit direct testimony in support of this, the stipulation on behalf of the Kroger Company, which is marked as Kroger Exhibit 1?
Yes, I did.
And was that testimony prepared by you or under your supervision?
Yes, it was.
Do you have any changes or corrections to your testimony?
No, I do not.
Thank you. Kroger moves to admit the testimony of Justin Bieber marked as Kroger Exhibit 1.
Okay. Pursuant to the stipulation, there's no objection, so Kroger Exhibit 1 is admitted into the record.
Thank you. And Mr. Bieber is available for questions.
Okay, thank you. Turning first to Chair O'Connell. Mr. Chair, do you have any questions for Mr. Bieber? Seeing none. Hearing Examiner Ryan.
Just a few questions, Mr. Bieber. On page 6 of your testimony, lines 6 through 8. These, I assume the word "there" should be "these" on line 6.
Let me take a quick look. Yes.
It's fine, and it's there's always typos. It's all good. So I just want to make sure I understand the sentences at lines 5 through 8. Rate schedule 3B components will align with the unbundled cost of service outlined in PNM's application. What do you mean by unbundled cost?
Yes, so the unbundled cost of service unbundles the different classifications of rates. So you have your customer related costs, your demand related costs, your energy related costs. So instead of having any intentional recovery of, say, demand-related costs through the energy charge, that would, you know, instead of doing that, you would align it with the unbundled cost of service in that manner.
Okay. Then moving to page 8, and the answer you provided, lines 2 through 8. You're right, beginning at page 4, or sorry, line 4 on page 8. The continuation of recovering ESA costs through base rates ensures demand-related costs associated with ESAs can continue to be recovered through demand-based charges for demand build rate schedules. Is there a way you could put that so that it simplifies what the statement is there?
Yeah, so currently the ESA costs are recovered through base rates, and they're primarily classified as demand-related costs. And for rate schedules that have demand charges, so typically your non-residential rate schedules, the majority of those costs are recovered through demand charges. In the application, had the ESA costs been recovered through the FPP CAC function, it would have been a dollars per kWh charge, which in my opinion would not have aligned as well with cost causation, or would not have aligned with cost causation. So I was pointing out that this is a good thing in terms of aligning rates with the underlying costs for that specific category.
And then, and I wasn't sure if I saw this in your testimony, and it may be that, you know, Kroger's not necessarily interested in broadcasting the information, which I understand, but I was trying to just get assessment of what this meant in terms of savings for Kroger as a client. What did the stipulation provide for in terms of reduction in the total, if any? I can't remember where we started and where we ended up with the rate,
right?
The service, the rate that Kroger usually is provided service under.
Right. Kroger takes rate schedule or service on rate schedule 3B. And for Kroger, it is a good thing to align the rate design with the underlying costs, as opposed to having any sort of intentional, say, recovery of demand-related costs through energy charges.
Well, and my question is just more generally, between where we started in the application to where we ended up in the stipulation. I mean, what was the difference for Kroger and the rate classes that, or was that analysis not done?
The analysis is not complete yet. We typically do that analysis at the conclusion of the rate case. So because rate 3B, as well as almost every other rate schedule, is getting a lower rate increase than was proposed in the application, Kroger, you know, being on rate 3B, will see a lower rate increase. It'll be approximately the similar reduction as what was seen for the class overall. There will be a little bit of a difference due to the what I consider an improvement in the rate design, so aligning it with the unbundled cost of service that we talked about just a moment ago.
And then I apologize, yeah, sorry, no, that's fine. I appreciate that answer. The one question as you were talking about just sort of occurred to me, and I don't know the answer, and maybe this is in your testimony, I'm not sure. Is Kroger, the rate 3B subsidizing? I mean, does the rate 3B class provide subsidies to or is that, or no?
No, in this settlement, the rate 3B is getting a cost-based rate increase.
Okay. Okay, thank you. That's all the questions I had for Mr. Bieber.
Thank you, Hearing Examiner Ryan. Good afternoon, Mr. Bieber. I just have one question for you. My main question was the rate schedule at which Kroger took service. I'm just curious, you know, given the nature of Kroger's business and in New Mexico, And the fact that it's customers, I would imagine, are predominantly taking service under the residential rates. Does the interest of those customer classes at all factor in when you're working on behalf of a client like Kroger? Does the interest of the residential classes factor at all into your analysis when you approach, a rate case like this?
Yes, it does. When I participate in a rate case such as this, though, I'm giving my expert opinion, typically based on the rate making principles that I believe in, which do include gradualism. So I do think it's important in this case and in other rate cases that you temper movement towards cost for certain rate classes, depending on the circumstances. It so happens to be the case with Kroger that residential customers, they share similar customers. So that is something that's considered, but it also aligns with my expert opinions on the cost allocation and rate spread.
Okay, that's helpful. And Kroger, I mean, the just to clarify what I think I heard you just say, that rate 3B, that's not really a subsidizing class. That's just receiving an increase at their cost of service.
That's correct for this proceeding.
Okay, that's great.
And sorry, just one follow-up question that what the hearings Governor Crankamp asked there was made me think of something. And I mean, is the reason why you're considering what is the impact in the residential class because the residential class is Kroger's customers?
Well, I acknowledge that is a consideration when I do work on a client, on behalf of a client such as Kroger. But when I'm evaluating the rate spread and the cost allocation, I do base it on cost of service principles, but recognize that should also be balanced with gradualism.
Okay, thank you.
Excellent. Thank you, Mr. Bieber. Those are all the questions that I believe we have for you. Mr. Beam, do you have any questions on redirect, sir?
No redirect. Thank you.
Thank you. Unless there's any final questions, Mr. Bieber, thank you very much for your time today and your testimony. We do appreciate it.
Thank you.
Thanks, sir. Okay. That brings us, I believe, to you, Ms. Clark, and Walmart. You can call your first and only witness.
Yes. It will be calling Jamie McGovern, Dr. Jamie McGovern. I am trying to, she just logged in. Okay, thank you.
Looks like she's on right now. And Mr. Lee, whenever Dr. McGovern is able to turn her video on, then you can please swear in the witness.
Dr. McGovern, would you unmute yourself, please, and raise your right hand? You solemnly swear the testimony you're about to give, no matter not pending, should be the truth, the whole truth, nothing but the truth?
I do.
Thank you, ma'am.
Go ahead, Ms. Clark.
Thank you. Please state your name for the record.
Dr. Jamie McGovern.
By whom are you employed and what is your position?
Walmart Energy, Senior Manager, Regulatory.
You have before you what's marked as Walmart Exhibit Number 1, which is your direct testimony in support of the stipulation filed in this proceeding?
I do.
Was your direct testimony prepared by you or by someone under your direction?
Yes.
Do you have any changes or corrections to your direct testimony?
I believe I have a typo that Walmart has 36 retail stores. I've stated 26.
Thank you. Is your direct testimony true and accurate to the best of your knowledge, other than that one correction?
Yes.
If I were to ask you the same questions contained in your direct testimony, would you provide the same or similar response?
Yes.
Excuse me. I request that Walmart Exhibit Number 1 be moved into evidence.
Thank you, Ms. Clark. Per the stipulation, there being no objection, Walmart Exhibit 1 is admitted into the record.
And I tender the witness. Thank you.
Thank you very much. Let's see. I think I don't see a commissioner on, so that brings us to you, hearing examiner Ryan.
Ms. McGovern, Dr. McGovern, I see in your testimony, Walmart receives power under 4B and 3B. That's correct?
That's correct.
And I apologize if this is available elsewhere, but just for clarity of the record, does that make Walmart effectively, with whatever increase it's receiving here, similar to Kroger, and that it's whatever increases impacted is, or given is provided as a consequence, the cost of service increases?
We have similar situations as Kroger, yes.
Okay, so in other words, Walmart is at this juncture not contributing towards other classes in the form of subsidies of the type we've been discussing at length?
Hearing examiner Ryan, I was on for Kroger's witness on the YouTube, and I had to sort of step out to hop in on this channel. But I think that I heard that Kroger only takes power on 3B, but we also take power on 4B, so that there's a slight difference there.
Well, and I guess like the broader question was asking is Walmart in the form of rates contributing towards other classes, specifically the residential class?
I believe historically that the 4B power has, or 4B rate has been a subsidizing rate.
Okay. And then similar to the question I asked Mr. Bieber, when you were preparing for the rate case, was the question effectively for Walmart, what is the projected increase in cost for electricity, and then what will we save? And did you calculate that and then use that to determine whether or not the stipulation was in Walmart's interest? I mean, at a very percentage level, I understand that basically why would anyone, but what I want to know is, do you go in and sort of examine, hey, here is the exact costs, and that's a good outcome for us, and did Walmart do that here, and what was the actual savings?
Thank you. So yeah, so for Walmart, I do look at what our projected growth and costs will be, given that our services continue to expand. There's some that isn't a conclusive analysis. There will be savings from the settlement. I would say, generally speaking, Walmart supports cost-based rates. So we tend to look at movement towards cost-based rates and reasonable ROEs and capital structures. And those are kind of our approaches when we look at cases often.
If I understood correctly, the correction you made was to say in the testimony is that Walmart has 36 stores, not 26.
That's correct. And just to add to that, we're generally across the country expanding service to add things like EV charging and some automation. So it changes our electricity usage even within its same store footprint. If we automate internal processes.
Given that the residential classes are, I mean, I without making any assumptions about Walmart's full business, but presumably a lot of it is selling consumer products at retail stores. Do you do analysis around what is the impact in terms of sales projections and store profits based on increases in residential energy prices? In other words, if folks have to dedicate more money towards energy, they're unable to go and dedicate that money towards retail products at Walmart's stores. Do you do that sort of analysis when you're thinking about what the rates should be?
Walmart cares very much about residential customers, and we're very aware that PNM's customers are also our customers. And that's a concern for us. the same time, we don't do analysis on the rates and the rate impacts for residential customers.
On Walmart sales. So we don't know, for instance, if rates increase, say $10 on a residential class, like what is the impact on that on Walmart?
The secondary impacts, no, that's not what we do for the rate cases.
Does that get done in other contexts?
Unfortunately, I'm sorry, I can't answer that I work in the energy section, and that's not something I have knowledge of. I can look into that for you.
No, it's okay. It just seems to me like, same store sales or sort of the way you do, successive retail and Walmart, you're widely broadcast yourselves as a store that sells products to people who are looking for the most competitive prices. And it would seem to me that the more those folks looking for the most competitive prices are squeezed, the less sales you'll receive. So I just was wondering if there's any sort of data that would indicate sort of feedback loops.
Hearing examiner Ryan, I do apologize that I don't have that, and it makes sense to me that Walmart does a lot of analysis. It may include that. I came to Walmart about 9 months ago from some consumer advocacy in California. So I'm aware of that type of analysis, and I've done that sort of work. But I don't have that long of a tenure at Walmart, so I'm not aware of all of our operations internally.
Very good. Thank you very much. Appreciate it.
Thank you.
Good afternoon, Dr. McGovern. I just have, following up on hearing examiner Ryan's questions, I really only have, I think, one question for you. I'm just trying to get a better handle on how it is that Walmart takes service and under what rate schedules. And I'm looking at page 3 of your testimony, where you describe, and that, with the correction, I think of 36 retail stores. And then you say 1 distribution center and related facilities in PNM's New Mexico service territory. Are your retail, do you know what rate schedule your retail stores would fall under?
Let me have a look really quick.
I'm just wondering if maybe your retail stores would fall under 3B, and then the distribution center potentially as a larger facility might fall under 4B.
Give me 1 second. I believe that's correct. I think I'm looking here. The sort of quantity that we have. That seems to make sense to me as I'm scrolling through our sort of aggregated billing. And it seems that we may also have one of our stores on 2B. And so if our stores are super centers, I think they're probably likely to take power on 3B, and maybe we have some ancillary or one of the sort of neighborhood markets or smaller stores on 2B.
Okay. And you mentioned previously installing more EV charging, things like that. Will that ultimately impact the rate schedules at which Walmart will take service?
That can impact the rate schedules if some of the rate schedules are capped. But it's possible that if they are located in, say, an area where our super center is, And it's an uncapped schedule that would just be included in the service that we're taking at our super center,
Okay.
for example.
And you said with that correction, it's 36 retail stores. That's just in PNM service territory?
That's correct.
Okay. All right. I think that's all the questions I have for you. Thank you very much for your testimony, Dr. McGovern.
Thank you.
Any further questions, Hearing Examiner Ryan? Okay. Let's see, Ms. Clark, any redirect?
No redirect.
Okay, thank you. Well, no further questions for you. Thank you very much again for your testimony today, Dr. McGovern. And with that, you're excused.
Thank you.
Thank you.
Thank you. And may I be excused also?
Yes,
Thank you.
thank you. All right. Moving right along. I believe we are now down to our final two witnesses, both of whom are staff. Mr. Rossi, you're back up.
Thank you, Mr. Hearing Examiner. Staff will call Alicia Leyva Tucero.
Okay. Mr. Lee, if you'd please swear in the witness.
Ms. Labature, sir, would you raise your right hand, please? You solemnly swear the testimony you're about to give, no matter now pending, should be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you, ma'am.
Go ahead, Mr. Rossi.
Thank you, sir. Good afternoon, ma'am. Can you please state your name for the record?
My name is Alicia C. Leyva Tercero.
And how are you employed?
I'm employed as the Economics Bureau Chief in the Utility Division of the New Mexico Public Regulation Commission.
As part of your duties, did you review this application?
Yes, I did.
And did you prepare testimony for this proceeding?
Yes.
Do you have a copy of Staff Exhibit Number 5, Testimony of Alicia Lee C. Leyva Tucero in support of the unopposed comprehensive stipulation?
Yes.
Was this testimony prepared by you?
Yes, it was.
Is this exhibit your sworn testimony in this matter?
Yes.
If I asked you the same questions today, would your answers be the same?
Yes, they would.
And are the answers true and accurate to the best of your knowledge?
Yes.
At this time, I'll move to admit Staff Exhibit Number 5.
Okay, thank you. Per the stipulation, there's no objection, so Staff Exhibit 5 is admitted into the record.
I have no further questions for this witness. Maybe she may be subject to questions.
Thanks, sir. Hearing Examiner Ryan.
Good afternoon, Ms. Leyva Tucero. I'm just going through your testimony real quickly, and I'll come to my questions in just a moment.
Good afternoon.
I asked Dr. Gigax this question. I'll just ask you too for clarity. It's my understanding that the as-filed application was one of the largest or the largest rate increase request the company has made ever. Is that correct or incorrect, or do you know the answer?
My knowledge, that's correct. Yes.
It is the largest rate increase they've requested.
Yes.
We had lengthy discussion. You know, the whole case is, I mean, in many ways, everyone's come in, they've come to an agreement, but that, you know, still leaves the future uncertain in the sense of, you know, what is the long-term plan? We had, you know, very active discussion with Dr. Gigax and Ms. Crane about how we solve the problem of the residential class subsidies. What is staff's position on what is the long-term solution to that problem? Does staff have a position on that subject?
Well, I don't know that we have a perfect solution to that problem. I think as you've heard from other testimonies, you know, I think rates are going to continue to increase into the future. And so these subsidies are likely can continue to increase. I think that some things that we can do to help to lessen that are things like, you know, time of use rates and energy efficiency. Although I do think that, you know, there are some concerns there. There may be a lack of education and outreach regarding these types of programs. Also, perhaps some customers may not be able to take advantage of energy efficiency, may not be able to afford energy efficient appliances, things like that. We also have, life, and people might not be able to shift their usage. We have, jobs and schedules, and while you might be able to set your dishwasher before you go to sleep, you might not be able to do your laundry in the middle of the night. So, I think there's things that we can do to help to resolve these problems, including better education and outreach on our time of use programs. Historically, I know there's been low participation rates in those areas. And we do have some new pilot programs. I think we are increasing education, but that could be something that we can improve upon. Also, what we're working through in the PRAC with trying to come up with new allocation methodologies that might potentially reduce some of the subsidy that exists. The way you allocate things has an impact, definitely. And then I think what we've done in this case, I did have some major concerns when I looked back at the prior rate case, which I was not involved in, but when I saw that level of subsidy that existed as a result of that case with the about $48 million. And so I do think we need to make some meaningful movement toward reducing that subsidy. And I think we've done that here in this case. We're now at $40 million. So that is making some progress.
So is it staff's position that to the extent to which there is need to subsidize at all, because there is a concentration of low-income ratepayers that exists in PNM service territory, a high concentration, that those subsidies are best dealt with outside of rates? I mean, does staff take that position?
I agree with some of the comments that have been made about having a legislative approach to that and increasing energy assistance and funding for energy assistance programs. I do agree that, the rate making process is complicated enough as it is. And so adding to that through things like low income rates, which we can't really implement right now under our current statutes, but I know that there have been proposals on that in the past and maybe in the current legislative session, I don't know. But those are other forms of subsidy within the rate making process. So. But I do think that for right now, with what we have, we do need to mitigate the impact on our most vulnerable ratepayers through things like banding and the phase-in approach that we've taken in this case. So.
At page 7 of your stipulation testimony, you describe a recommendation regarding the advice notice 625, a refiling, and then as to phase 2, an advice compliance notice, a compliance advice notice. Do you have any reason to believe that PNM objects to this? I mean, or is that this is just sort of dotting T's or dotting I's and crossing T's?
Yeah, just we didn't have detail within the stipulation on how those would be filed, and so yeah, I just wanted to try to make that clear here. I think what I've recommended is consistent with how this has been handled in the past, but also providing that additional information similar to the schedules that are provided here, under the stipulation. I think those should also be provided with the phase 2 rates, because information might change. For example, the changes that are contemplated by paragraph 17E of the stipulation regarding the federal corporate income tax changes. So I think we need to have this information updated at the time of filing the phase 2 rates.
Yeah, and again, my question, really was, do you have any reason to believe that PNM, and then your answer was understandable. I'm just saying, is there any reason to believe that PNM would challenge that in any way?
No, I don't believe so.
Yeah. Um, those are all the questions I have for Ms. Leyba-Tercero. Thank you very much.
Thank you.
Thank you. Good afternoon, Ms. Leyba-Tercero. Thank you very much for your testimony.
Good afternoon.
I only have a couple of questions following the questions that Hearing Examiner Ryan asked you. I wanted to ask you just a little bit about the sort of phase in of the rate increase. We haven't really talked that much with some of the other witnesses about that. And I just wanted to ask you a little bit for clarity in your testimony. I'm looking at page 5 in particular. And you're asked about section 5 of the stipulation, which is the sort of the phase in. And you said that staff believed that the rate increase should be phased in over a 12-month period rather than the 6-month period conditionally proposed by PNM in its application. When you're saying that, is that a reference to the application in this case where PNM was proposing the first phase on July 1st of this year and then the second phase on January 1st of next year?
Yes, that's correct.
Okay. And my understanding is that that type of phase in, those dates are the same in the stipulation. Is that correct, or am I wrong about that?
And so there was a 6-month period proposed in the application, and the stipulated phase-in is a 9-month period.
Oh, I see. Okay, so then what's the date? What are the two dates then?
It's July 125 and April 120. Yeah, April of
2026.
Yeah.
Okay. All right. And why was that additional 3 months important to staff?
Well, given the extent of the increase, this is why staff initially disagreed with the conditional phase-in, and with the 6-month, just based on the extent of the increase, this was another way to help to mitigate the impact on the ratepayers. And traditionally, we've seen a 12-month phase-in. I provided some examples within my testimony. So initially, I believed that 12 months was appropriate. The 9 months was a compromise, and I think it was reasonable given the stipulated rate increase.
Okay. That phase in, along with the reduction in the sheer volume of the revenue requirement, is that sufficient in staff's view to avoid rate shock, at least in the residential class?
I believe the phase-in and the banding approach that is applied here is reasonable and a gradual approach that's consistent with what the commission has applied in the past.
Okay. I don't think I have anything further for you. Thank you very much for your testimony.
Thank you.
Hearing Examiner Ryan, anything further?
No.
Okay. Mr. Rossi, anything on redirect?
No, sir. Thank you.
Thank you. Ms. Leyba-Tercero, thank you very much. We appreciate your time and your testimony. You can be excused. Okay. Last up is Mr. Jimenez. Mr. Rossi.
He's being admitted right now.
Okay.
Staff will call Dr. Edison Jimenez. Thank you.
Mr. Lee, if you would please swear in the witness.
Mr. Jimenez, would you please unmute yourself and raise your right hand? Mr. Jimenez, would you raise your right hand, please? You solemnly swear the testimony you're about to give in the matter of opinion should be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir.
Go ahead, Mr. Rossi.
Thank you, sir. Good afternoon, doctor. Could you please state your name for the record?
My name is Edison Jimenez.
And how are you employed?
I'm employed as an economist in the Economist Bureau at Utility Division at PRC.
As part of your duties, did you review this application?
Yes, I did.
Did you prepare testimony for this proceeding?
Yes, I did.
Do you have a copy of exhibit or staff exhibit number 6, the testimony of Edison Jimenez in support of the unopposed comprehensive stipulation?
Yes, I do.
Was this testimony prepared by you?
Yes, it was.
Is this exhibit your sworn testimony in this matter?
Yes, it is.
If I asked you the same questions today, would your answers be the same?
Yes, they will.
Are your answers true and accurate to the best of your knowledge?
Yes, they are.
At this time, I ask to admit staff exhibit number 6.
Thank you. Per the stipulation, there's no objection, so staff exhibit 6 is hereby admitted.
I have no further questions for this witness, and I tender him for further questioning. Thank you.
Thank you. Hearing examiner Ryan.
Just a few questions, Mr. Jimenez, Dr. Jimenez. Some of the questions I had planned to ask you have been addressed satisfactorily by other witnesses. Conceptual matters. Can you explain I would like some clarity about the discussion in your testimony at page 11 about this is that between line 7 and 17, where you answer the question, why does staff support the stipulation's proposed increase to the whole home electric vehicle rate? Can you just go ahead? Sorry.
Sorry to interrupt you. After staff review the rate design, this number called our attention is a big increase. I believe is 80 something percent increase. 82% is the increase in the whole house EV rate. But then we were reviewing high speed arguments about it to defend this, and we agreed.
That's right.
So
Excuse
basically,
me.
they are like
Hang on, Mr.
mostly
Jimenez.
of
Hang
the
on.
customers
Hang
enroll
on.
in
Mr.
this.
Jimenez.
Excuse me, Mr. Jimenez. I'm sorry, I sort of lost the thread there. If you could speak a little slower and start with, but then we were reviewing.
I think there's but I think there's actually a bit of lag going on in Mr. Jimenez's video feed and audio. I think.
Yes, I'm having some connectivity issues. If you allow me 10 seconds, I can go and check the modem.
Sure.
I apologize, gentlemen. I'm just having a little trouble understanding him was all.
No,
problem,
it's
Mr. Lee.
understandable, Mr. Lee. Yeah, and I think actually there was the slight bit of lag that was occurring was making it harder. So I think if we can fix that, then I believe if he slows down speaking a bit, it'll be easier for you.
Thank you. I'm back on the record.
Since internet is not working well in Santa Fe these days.
Yeah, that's so I can just tell from the video that it's there's some lag.
Still?
Yes.
We can try. I mean, I think we're probably going to find that there is, but why don't we just start over? So I'll just re-ask the question. Basically, I was just asking you to clarify your testimony on page 11 relating to the statements of the whole home EV rate, and I think you indicated, Dr. Jimenez, that staff noted that there was a large increase. I believe you said what was the total percentage in numbers?
The increase in
Yeah.
this rate was 82%.
82%. Okay. And then you were gonna go on and say some other stuff about that. So please go ahead.
Well, I was about to say that we were reviewing the numbers, and it happens that mostly of the users of this rate, the people that is being charged for this rate, are mostly located in the block 3 of the residential. You know, there is block 1, 2, and 3 for the levels of consume. So mostly of these people is in that block 3. So the thing we did was to compare the energy rate in this block 3 with respect to the whole house EV, and it's still a good offer. It still offers a good benefit for the subscribers to this program. Also, I believe I mentioned also that if you compare it as well with the time of the day rates, it happens that the whole house EV is still also lower than the time of the day. So even though that the increase is 82%, subscribers to this program can be sure that they will receive a big benefit, a big saving on this program.
Moving on to page 12, lines 8 through 16. There were two figures here. I didn't understand. The first sentence of this paragraph of testimony indicates that Dr. Pitts has testified as of June 2024, PNM had 241 enrolled customers in the time of day pilot rate program. But then in the last sentence there, moving down to lines 12 through 14, there's writing that says, by the first week in June 2024, there are 587 residential customers and 122 commercial. I just didn't understand how those numbers, was that in like, are those dates correct, or what am I not understanding there?
You are good enough on my end, but I believe I understand the question. So basically your question is why there is a difference of numbers?
Right, because when I read it, I thought,
the end.
yeah, as of June 2024, you're saying there's 241 customers in the time of day. And then by the first week of June 2024, there are all of a sudden 587 residential and 122 commercial, which is a lot more, unless in a week period of time, that's how big it grew.
My understanding is they subscribe, but they need a meter, a special meter for the time of the day. So they are like, I will say like pending. This 587 residential customer it seems is pending. So they are subscribed, but they are still not taking this rate.
Okay. Okay, I think I understand that distinction. When you were assessing the merits of the stipulation, one of the things that I thought was very useful that Dr. Gigax and Ms. Crane did was to, tell the commission, look, had we inquired into this rate case as a fully litigated matter, we likely would have come to a conclusion just objectively that is very close to where the stipulation ends up. So in that sense, it's not that the stipulation is itself independently a great deal, but that it just aligns with what we would have recommended anyway. Is that what staff concluded here, or was that something that staff did not do?
I will say previous the settlement, previous the stipulation, of course, the staff were working in their numbers, and they were very close, very similar to the New Mexico Department of Justice. We arrived to a banding very close to that. I believe our banding was 150 and 47%. So our analysis was close to New Mexico Department of Justice and also was very close to what we reached in the stipulation.
Okay, thank you, Dr. Jimenez. That's all the questions I have, Hearing Examiner Klein Kim.
Thank you. Let's see. Good afternoon, Dr. Jimenez.
Good afternoon, Hearing Examiner.
I just have a couple of questions for you.
Okay.
One, I'm not sure how much of the testimony of Dr. Gigax this morning you were able to hear, but we had a fairly lengthy dialogue with him about customer charges and intra-class subsidies. And there was a question that was raised as part of that discussion about the extent to which there might be overlap between low usage and low income ratepayers. Do you know if there's any correlation between those two groups of ratepayers? You're not able to hear me?
It was cutting. Let me try to do something, please.
Okay.
I'm sorry for this.
No problem.
How about now?
I can hear you. Can you hear me?
You know what? I think it's the monitors. I was plugging the monitors and I don't know what's happening, but as long the laptop is alone, it's working well. So can you repeat or rephrase the question? Sorry.
Sure. We had a dialogue with Dr. Gigax this morning about customer charges and intra-class subsidies. And there was a question raised during that discussion about the extent to which there might be an overlap between low usage within the residential class, low usage customers, and then low income customers. You talk a little bit about customer charges in your direct testimony and staff's general approach towards customer charges for the residential class. Are you aware of any correlation between low usage and low income ratepayers? And does that inform staff's approach to customer charges?
Yes, we are aware of the correlation. We will find low income customers that will be located in the block 1 because they consume little, but we will have a bunch of them also located in the block 3 because their houses or properties doesn't have enough, let's say the conservation of energy in these houses is not good, and they don't have the money resources to make the repairments or implement these energy efficient measures. So yes, staff is aware of this issue, but we are trying mostly to promote the conservation. So that's what we want to do with the customer charge, is to promote the conservation and trying people to control or do a better plan with the consumption of energy.
Okay. So to the extent that there is that intra-class subsidy, it serves the purpose of promoting energy efficiency. Is that staff's general perspective?
I will say so, yes, that's a good statement.
Okay. But staff also sees that there's a need to move to reduce those subsidies in the long run and go towards more of a cost-based rate.
Yes, as all interveners have mentioned, in the past cases, the subsidized to residential and other class has just increased. So also we believe it's convenient and it's needed start to close this gap, but progressively, not like from one case to another. We need to arrive to that point, but step by step, you know.
Okay. Last question. Hearing Examiner Ryan asked you a little bit about your testimony concerning the time of day pilot. Do you recall that?
Time of the day pilot, yes.
You, on page 13 of your testimony, you talk about the stipulation to maintain the rate design of the time of day pilot. And you talk a little bit about essentially staff agreeing with PNM that those rate design elements should be kept the same for the duration of the pilot rate. How long is that? What is that duration of that pilot rate?
The duration of the pilot, I don't know. I don't know how to answer that. I'm not aware of there is a deadline for this. I believe it's when PNN establish a new rate, a new energy rate for that time of the day rate. But I'm not aware that we have like a specific deadline or a specific day where this is going to finish. I'm not aware. Maybe it is.
Okay. Yeah, I'm just asking because, I mean, hearing examiner Ryan and I just finished a time of day, time of use rate pilot program for EPE that has a 1 or a 2 year duration. And so I was curious if PNM had a similar duration on theirs.
I'm not aware, but even if they have, as I mentioned in my testimony, at the moment the company filed this case, there was very little time in the time of the day effective date to the moment they file application. That's why staff consider it's appropriate to let it continue. So later we can do a better study of it, better in, how can I say it? Maybe we can do with more time and more data, we can do a better analysis in the future of it.
Okay. Thank you very much. Hearing examiner Ryan, any final questions?
No, thank you.
Okay. Let's see, Mr. Rossi, any questions on redirect?
No, Mr. Hearing Examiner, thank you.
Okay. With that, Dr. Jimenez, I don't believe there's any further questions for you, so you can be excused, sir. Thank you for your testimony.
Thank you and have a good afternoon, everyone.
Thank you. Okay. I believe that concludes the testimony portion of the hearing today. Okay, I think we can go ahead and wrap up. Hearing examiner Ryan, I don't suppose there's a need to take a quick break and chat about any housekeeping items before we finish up.
No, and I would say, I mean, I speaking to hearing examiner Krankamp over our lunch break, and I think I said to him, I assume the parties are not going to want to have to supply briefing in this matter because that's generally the statement up we get when we are presiding over these unopposed stipulations. Hearing examiner Krankamp have heard all the testimony. We're familiar with it all. I don't know that I have any need to receive briefs from you all. Of course, this is your hearing as much as it is ours. So if you want to supply briefs, you're certainly free to do that. And as a matter of due process, the parties always remain free to do that in every one of these proceedings. But for purposes of efficiency, I understand everyone's very busy and their perspectives on this is that, the agreement was reached, it's unopposed. So I don't think we need to set a briefing schedule unless the parties present here would disagree.
PNM does not disagree, Mr. Hearing Examiner.
It's fine for us. I mean, I think maybe just for the record, the hearing examiner Krankamp and I will enter. I don't know. We'll just think the statements we have here maybe suffice for that purpose. I mean, other than that, I don't think there's a whole lot to discuss.
No.
Yeah.
We will produce a certification of stipulation along with a recommended disposition as required by the rules in due course. Are there any questions from the parties procedurally? Any remaining items we need to address before we adjourn?
Mr. Hearing Examiner, if it is the pleasure of the hearing examiners, PNM would offer to provide a draft of the certification of stipulation, if that would be helpful.
Well, I appreciate the offer, Mr. Verheul, but we're going to respectfully decline. We'll draft that on our end, sir.
Okay.
But thank you. Anything further from the parties? Okay, seeing none. Well, thank you all very much for your participation. Hearing didn't take quite as long as we might have anticipated beforehand, but we appreciate all of your professionalism and all the witnesses who participated. And with that, this hearing is adjourned and we are off the record. Thank you.
Thank you.